Good morning. Welcome to the Appeals Court. Let me introduce the panel. To my right is Justice Ditkoff. To my left is Justice Tan. And I am Justice Shin. We will be your panel for all 6 cases on the list today. As many of you know, the rules of oral argument are each side gets 15 minutes to argue. When the yellow light goes on, you should start thinking about wrapping up your argument. And when the red light goes on, it means your time has expired. And for better or for worse, we do not allow rebuttal in the appeals court. You can be assured that the panel has read all your briefs. We are familiar with the record, so my best advice would be to get to the heart of your argument. The last thing I will say is that these proceedings are being recorded and streamed. So if you're in the audience observing and you're sitting in the middle behind the podium, the camera will pick you up. So if you do not want that, and I'm thinking in particular of anyone here observing an impounded case, you'll want to sit to the sides of the podium on the left and right side. All right, I will call the first case. I apologize if I mispronounce the name. It's NIKOLA ZDUNIC versus GENESYS LLC, case number 2025P 1067. The attorney for the appellee is here in person, and the appellant, AJ Reddy, is appearing by video conference. Can you hear me, sir?
Yes, ma'am.
Okay.
Yes, Your Honor.
I know you don't have, can't see the lights, so I will try to give you a signal when your time is starting to run out, when the yellow light goes on, okay? You may begin your argument. Mr. Reddy, you may begin your argument.
Yes. May it please the court, Ajay Reddy, pro se appellant. Thank you, Your Honors, for allowing me to appear remotely. I'll keep this to 2 points that matter most. I understand appellee frames several issues as waived or imperfectly preserved. My submission today is narrower. This is not a Rule 12 personal jurisdiction objection. It is a statutory scope issue under Taylor and General Laws, Chapter 149, Section 1. And even if the court has preservation concerns about Taylor, the judgment against Ajay Reddy personally still cannot stand because the jury was never asked to decide the statutory predicate required for individual liability under Section 148. First, under Taylor, Massachusetts did not have the most significant relationship to wage earning services and employment relationship at issue. Section 1 of Chapter 149 points the same way. Chapter 149 does not apply where the greater part of the work is to be performed outside Massachusetts. The question is not whether Massachusetts had some contact with the parties, but whether it had the most significant relationship to wage earning services and employment relationship at issue. Appellee's Massachusetts-centered premise is contradicted by the objective record. The 2016 annual report lists the company's principal office in South Portland, Maine. The 2017 and 2018 annual reports list it in Marietta, Georgia. The joint pre-trial memorandum also identified Marietta, Georgia as GENESYS' principal office of business. COO, Chief Operating Officer Jack Speranza testified that the company's principal place of business shifted to Maine and then to Georgia in the 2016 to 2017 timeframe. So, I testified.
So, sir, what states do you think had the most substantial interest, and at what times?
In 2016, sir, the principal office was South Portland, Maine. And 2016, end of 2016 to 2017 and 2018, it was Marietta, Georgia.
Thank you.
I testified that my apartment in Marietta, Georgia served as headquarters. Plaintiff testified when asked whether he did any work in Massachusetts. His answer was, no, I don't. The admitted payroll documents also use the Georgia address. And even in Appellee's own factual narrative, places the work done in Chattanooga, Australia, Portland, and Michigan rather than in Massachusetts. On this record, Massachusetts did not have the most significant relationship to the wage earning services and employment relationship at issue. Second, even if the Wage Act applies, the judgment against Ajay Reddy personally cannot stand because the jury was never asked the question Section 148 required it to answer. The trial court itself recognized at the verdict slip conference that it could not simply say on the verdict slip that the defendant was a CEO and therefore responsible, because that was, quote, up to them, not me, unless there's a stipulation, unquote. There was no stipulation. Yet, the final charge later told the jury that personal liability was automatic and that it must find Ajay Reddy liable if it found GENESYS liable.
But your lawyer didn't object to that instruction, in fact, seemed to support it. So how can we review that on appeal?
My point is narrower, that it is, in fact, it's a statutory law that backs this up in 148. So the omitted 148 predicate is reviewable because it's a structural defect in the verdict. The jury was never asked to find Ajay Reddy had the management of wage payment, a required statutory element, and the court's instruction made liability automatic, despite acknowledging during the verdict slip conference that the issue required a stipulation of jury finding. That error goes to the integrity of personal judgment, which cannot stand without a jury determination on a necessary element of regardless of preservation. There was no stipulation, as I mentioned. Yet in the final charge later told the jury that the personal liability was automatic and it must find Ajay Reddy liable if it found GENESYS liable. The verdict form then asked only whether wages were unpaid or untimely and in what amount. It never asked whether Ajay Reddy was an officer or agent, quote, having the management of wage payment under Section 148. And that omission mattered. This was not an inevitable finding. The record permitted competing inferences about who functionally handled payroll, finance, and wage payment dispute. Appellee's own narrative says Diana handled HR, finance, and accounting during the relevant period. My testimony and the record appendix also reflect that payroll and administrative records were largely handled by Jack or Diana, that I asked Jack to address Nick's back pay issue, and I was not in charge of the finance element and did not know the specifics. So even under appellee's own evidentiary lens, the predicate was contested, and sufficiency cannot cure the fact that the jury was never asked to decide it. So there are two routes to relief. The broader route is Taylor. Massachusetts did not have the most significant relationship to the wage earning services and employment relationship at issue. The narrower route is the 148 point. The jury never decided the statutory predicate required to hold Ajay Reddy personally liable.
So are you dropping your argument that there wasn't sufficient evidence to find that you had management of the LLC? That was your third argument, but now you seem to be saying there was sufficient evidence either way.
No, sir, I'm not dropping my argument. I'm saying that this is a required thing, and in fact, if they weren't even given a chance, the evidence would have shown otherwise, and there were competing inferences that could have been taken up. My point specifically was that the sufficiency is not the issue here. The jury was never asked to make the finding at all. The statutory predicate under Section 148, whether I had the management of wage payment, was omitted from the verdict form. Even if there was sufficient evidence to support a finding either way, that does not cure the structural defect. I'm emphasizing the procedural error, not conceding the factual record.
Okay.
For those reasons, thank you. For those reasons, I respectfully ask the court to vacate the judgment against Ajay Reddy personally, either because Massachusetts did not have the most significant relationship to the wage earning services and employment relationship under Taylor and General Laws Chapter 149, Section 1, or because the jury never decided the Section 148 predicate for individual liability, whether Ajay Reddy had the management of wage payment. If the court does not grant full vacatur on the present record, I respectfully request at a minimum a remand for application of Taylor on the full record and for a proper determination of the Section 148 predicate, including, if necessary, a limited new trial on that predicate and any dependent damages with the proper instructions and a special verdict interrogatory. And if the court does not vacate liability, I respectfully request that the damages judgment be vacated and remanded for a new determination on a complete evidentiary record, including Jack Speranza's explanatory testimony and for any remittiture or settlement credit based on Diana Reddy's settlement as raised in the post-trial motion record.
So I didn't see any notice of appeal of the denial of the post-trial motion. Am I missing something? Did you appeal the denial of the post-trial motion? I didn't see that.
The notice of appeal covers the final judgment, which includes the denial of post-trial motions. We did not file a separate notice for the post-trial motion because the timely appeal from the judgment preserves all post-trial rulings for review. The issue were properly raised in the post-trial motion and carried forward in the appeal.
All right, you still have about 5 minutes left. Do you have anything else you want to say?
If there's any questions, I can answer, ma'am, Your Honor.
I don't see any questions. We have your brief. We understand your argument, so thank you very much. We will now hear from Attorney Curran.
Thank you.
Good morning. May it please the Court, Dana Curhan for ZDUNIC. Mr. Reddy has raised 6 claims. None of them is even remotely preserved. I will start with the jurisdictional argument, and that issue was never raised at any point during the course of trial. There was, in the complaint, there was, Mrs. ZDUNIC said, we have jurisdiction, and the answer, it says, well, we don't have to respond to that. The first time it was raised was in the motion for JNOV. And again, as this court correctly pointed out, no notice of appeal was filed after the ruling on the JNOV, so that's not properly before this court. I will say that the claim fails on the merits in any event. If you look at the employment contract, which is in the supplemental record appendix starting at page 24, it identifies GENESYS as a Massachusetts LLC, and at the end, there's also a choice of law provision applying Massachusetts law. Quite clearly, the LLC remained in effect, remained viable during the entire course of Mr. ZDUNIC's employment, and clearly there was jurisdiction, and there was no, in the absence of any challenge to jurisdiction, it is pretty clear that there was jurisdiction. I mean, everybody understood that there would be some remote work involved, and there was work in, I believe, Tennessee and Michigan, but the company remained a Massachusetts company even after, and this certificates from the Secretary of State's office are in my supplemental record appendix. But
so why do you say that the exclusion of the settlement negotiations and the exclusion of the parole evidence is waived? You said everything was waived.
There's no objection to that. There was some discussion, and the judge said, this is what I'm going to do, and the lawyer said, oh, okay, but didn't object to it. But in any event, that's settlement discussions are something that generally are not admissible.
But what was the disputed claim at the time that that conversation happened? What were they trying to settle?
I think they were talking about admission of various pieces of evidence that was under discussion. But, again,
I thought the testimony that the defendant sought to offer had to do with the conversation that happened in May of 2018. Is that right?
I think that's correct.
Okay, so what was going on in May 2018 that would preclude that testimony because of settlement?
I think what we're talking about is Jack Speranza. Mr. Reddy told Mr. Speranza to go and see if he can settle this, this wage claim. If I have my facts correct.
What's the claim? I mean, it seems like they're just trying to work out some sort of payment arrangement. Is that a settlement negotiation? What are they trying to settle? I'm not understanding.
Well, there was a dispute as to when Mr. ZDUNIC was employed, and whether there was a significant period in between the two assignments, the two remote assignments, and the question is whether he continued to be employed in between those. And there was also, during the second assignment, there were some, for example, there was a vacation which he wasn't paid for, or he was paid $3,000 instead of $10,000. And there were some disputes about that, and I guess Mr. Reddy told Mr. Speranza to go and see if he can work something out, negotiate this. Again, there's no objection anywhere to the judge's, any kind of ruling that the judge made, and there's no, when Mr. Speranza testified, there was no.
So the defense counsel tries to bring in the evidence. The judge rules it's excluded. I would have thought that would be enough to preserve. I didn't think after you present something and the judge says it's excluded, you have to say, I object to your ruling you just made.
I think what he had to do is, I think he did have to object, and I think he also, when Mr. Speranza testified, I think he had to say, look, you made a pretrial ruling, and it's a little unclear what the ruling was.
Is there a case that says that when opposing counsel objects and it's sustained, you have to then object to the sustaining of the objection against you?
Well, he didn't object. There was a discussion, and the judge said, here's what I'm going to do. And he didn't say, well, this prejudices me for the following reasons, and I object. And that's what you have to do to preserve it. And he could have also raised the issue at the time Speranza testified.
Okay, well, so, and that's not right. Mr. Shin, I'm on page 95, objection. What's the objection? Then he objects to it coming in, and the judge rules in favor of Shin. So I don't understand why you then have to object to the sustaining of the objection again. Is there something that says that?
I'm sorry, where is that?
Page 95, he tries to bring in this stuff. There's an objection from your predecessor. They have a discussion about it. And then in the end, the judge says it's going to be excluded at top of 98. And then no further questions at this point. So I don't understand why that doesn't preserve it.
Is this 98 of the supplemental record appendix?
Of volume 2 of the transcript.
Okay, volume 2.
It's like 328. I pulled out the transcript slide.
Okay.
I'm seeing 328. I assume it's from your appendix, but I'm just assuming that.
Well, yeah, Mr. Reddy did not. I attempted to negotiate the contents of the appendix. Mr. Reddy essentially told me to go pound sand. So I'm not sure if this is 328 of the supplemental appendix, or
I think so. I'm seeing a big 328 at the bottom of it. I assume it's
Okay.
from your supplemental appendix. I can't imagine what else. I guess I could check. Easy enough. No, your supplemental, it's the transcript appendix. Yeah, your supplemental transcript appendix. Yes.
Okay, so then that's at 328, which I have in front of me, but I'm not sure if I see,
Well, 328 is where the judge rules, but it's on 325 that Ms. Sheehan says objection. And then there's a discussion with the judge ruling in favor of Ms. Sheehan's objection.
yeah, I mean, I think the objection was well taken, that this was a settlement negotiation, and those are usually not admissible. And so I think I was thinking of, there was another part that was not objected to, but yes, there was an objection to that, but I think,
All right, I get you then.
I think the judge was absolutely right. This is a settlement discussion, and it is well within the judge's discretion to exclude this. So, you know, that really is the point. Are there other parts of the other arguments that the court would like me to address?
There is one thing I'd like you to do for me. I was very grateful for the supplemental appendices. They were really helpful. But I'd kind of like to see Exhibits 7 and 8. 7's the chart of damages, and 8's the October 2016 email. If you could get those for us, just submit it in a letter or supplemental appendix.
I'll see if I can find it. I think Mr. Reddy probably has it, but I'll see if I can locate that.
All right. If you can't, we'll circle. If you can't, if you don't have it, let us know, and we'll circle over to the defendant. But since you're the attorney, if you can
Yes,
put your hands on it,
yes.
it'll certainly be easier for everyone.
Yeah, I did my best to put together enough of an appendix that so we could decide these issues. I think,
That's a great appendix, and I'm grateful for it. But if I'd like those two documents, if you can lay your hands on them. If not,
let me see what I can do. Unless there are any further questions, I will leave the remaining points of the brief.
I don't see any. Thank you very much. The
Thank you.
case is submitted. Thank you, Mr. Reddy. Okay, the next case is Department of Children and Families and Another versus Father and Another, number 2025 P1124. And as I'm sure all of the attorneys on the case know, this case is impounded.
Thank you. Good morning. May it please the court, I am Jennifer Lamanna, and I represent the appellant father in this matter. The appellant father, unusually, was the petitioner in a Chapter 119, Section 24 proceeding. He appeared before a justice of the juvenile court, established the facts to justify a preliminary hearing going forward. The petition issued, and he arrived for his preliminary hearing to be met with an oral motion to dismiss by the Department of Children and Families. He was denied the opportunity to notice as required under Rule 7 of the juvenile court rules. And at the hearing itself, while the department now argues that it was purely jurisdictional and a forum shopping argument, the record clearly reflects that the department's argument and the child and the mother's argument at the time was fact-based. And of course, at a motion to dismiss hearing, what the fact-based argument should have been focused on was whether or not the allegations in the petition were sufficient and were presumptively true.
so sorry, go ahead.
But the judge made findings, right? She said, you know, the judge in the probate court who's been hearing this case for 3 years was in a better position to decide this, right? That was her basis for dismissing the petition.
That was the stated ruling, that she decided that the judge in the probate and family court who'd been hearing it was in a better position. But of course, the same question was not before the judge in the probate and family court. The judge in the juvenile court also acknowledged that the juvenile court absolutely has exclusive emergent jurisdiction of a Chapter 119, Section 24
Exclusive
proceeding.
jurisdiction?
Of a Chapter 119, Section 24
So
proceeding.
the probate court does not have jurisdiction to order custody of a child to the department?
The sua sponte, yes, the court can.
Under 11923A3, right? That's
Yes.
the mechanism in the probate
For
court.
the
that
probate court
judges
to do that.
can
But my
order-
client was the petitioner, so the argument that the word forum shopping was tossed around several times by the department
Your
and by
client could have
Mother's
asked in the
Counsel.
probate court for the judge to send the child to DCF custody, right?
I apologize, I missed the
Why
first half
couldn't
of
your
question.
client in the probate court ask for DCF custody of the child?
Why didn't he or
Or
couldn't he?
why couldn't he?
Perhaps he could have, although
So if there's
It's an
two,
unusual- it's
if
an
there's
unusual
two,
thing
if
for a
there's
litigant
two
to do in
forums in
probate
which you can
court.
do something, and why isn't he forum shopping?
So, first of all, there was a pending complaint for modification in the probate and family court. 2 days of trial had taken place. The parties had submitted their proposed findings of fact and rulings of law, but that complaint for modification was still open. No judgment is still issued to this day, as it happens. My client came forward with an emergency motion seeking custody of his child based on this violent incident caused by the mother in her home. The court did not grant him a hearing on that, scheduled a hearing several months out. He, believing his child to be in imminent risk, in July, so additional facts
Before we get
occurred
into
after
July, so in June, he
Yes.
signs a stipulation saying that mother gets custody of the child. It's in the probate court. There's a June 25th stipulation filed in probate court that he signed saying that mom keeps custody. So when that happens, how can he come in to juvenile court and argue for something different than that?
Because there was a different situation by the time he came to the juvenile court. Aside
Okay,
from the fact,
what happened between June 25th and July 2nd?
he stated clearly in his petition on July 2nd, over the last 3 weeks, he said, my child has had multiple injuries, bruises on his body, bumps in his head, a black eye. Every day, his physical and emotional status regresses. He stated that before the juvenile court on July 2nd. The Judge Donahue, who was reviewing that petition, specifically asked the DCF whether or not they objected to the petition issuing. They did not. So then it became a matter for the juvenile court to hear. He was entitled to a hearing based on the sufficiency of the petition as had been already determined by the first judge at that emergency
So
hearing.
I still don't know the answer to my question, which is, does the juvenile court have exclusive jurisdiction, as you said? Or could your client have asked for custody to DCF in the probate court?
I have never seen that happen. I have never seen
Okay,
in the
but
probate
could
court.
he? Do you know?
Could he or did he? I know he did not.
Could he?
I don't believe that he could. I've never
Why
seen
not?
a parent file, because if he were to have filed an emergency motion in the probate and family court asking for custody to transfer to DCF, I'm not aware of any statutory mechanism for the judge in the probate court can do so sua sponte, but I've never seen a party
What's
come
the authority
forward.
to do it sua sponte? Is it statutory?
I think as
Under
it's
Section 23? Is it?
Section 23
But the authority
authorizes-
is only sua sponte?
I don't believe there's anything in 23 that says upon the petition of a litigant in the probate court. I'd have to review it. 23 was not the
I
focus
think,
of
I
my
think the
argument.
language is that it's, the department may receive custody
Right.
order
Sua sponte.
based on
from the-
a,
yeah.
well, it doesn't say sua sponte, but it says based on an order of the probate family court.
So I've never seen what the court is discussing here, which is whether or not, but again, he filed a Chapter 119, Section 24 proceeding. He had no ability to file that petition in the in the probate and family court. Section 24 is very clear that the petition needs to be filed in the juvenile court in the jurisdiction where the child resides.
But if the relief that he's seeking is available in the probate court, I think that's what the questions are directed at, right?
The relief that he was seeking was the opening of a care and protection and a determination that the child was at imminent risk of harm or neglect. That was the relief he was seeking. That was not available to him in the probate court. In the probate court, what was available to him is what he
I mean,
filed.
that's not relief. Relief is having something done to protect the child. Relief isn't a finding or just an opening of a case. So what's the relief if it's not having the child go into DCF custody?
He was seeking, well, the relief that he was seeking was an opening of a case which investigates the actual underlying fear that he had for his child's safety, which he specifically noted in his petition. So the issuing judge, the judge who issued the first, who allowed the petition to go forward, was made fully aware of the fact that there was an ongoing probate and family court proceeding, that he had sought emergency relief there.
Okay, so if the relief is an investigation, why can't you ask a probate judge to investigate whether there is abuse or unsafety of a child? I thought probate judges did that all the time, appointed GALs, investigators.
It's a completely different mechanism for proceeding. So in the probate and family court, a party comes in and alleges their child is not doing well in the custody of the other parent. They allege, I should have custody, maybe the grandma, they can, generally it's between the parties there. DCF is not a party, the child doesn't have counsel. In the juvenile court, a petition is filed alleging that a child is suffering from one of the 4 factors that are enumerated in the statute, and there are immediate things that happen. The child is brought before the court and examined. Counsel is appointed if the parties are indigent. Counsel is appointed for the child. After the petition is issued, a court investigator is automatically appointed to conduct an investigation. That does not occur in the probate court. All of those things are optional and discretionary in the probate court, whether a guardian ad litem is appointed.
But Attorney Lamanna, right, though, again, back to the question, the relief that you sought, that your client sought when he walked into the the juvenile court and filed the affidavit and got the 24, Chapter 119, Section 24 petition, was that his concerns were, basically, he wanted the child to be removed from the mother, correct, and placed either with him or with the department.
Correct.
That could have happened, right, in the probate court through 119, Section 23A3. Even though I understand that it was a separate probate action that was in existence at the time that was being litigated, however, he did in fact file the motion, numerous ones, right, and he didn't get a hearing. But then, as you mentioned, the probate judge actually scheduled an additional day in August. He went into the juvenile court in July, and then the judge has scheduled a date in August, an additional date in the probate case.
Correct.
For the purpose, am I correct? I think you mentioned this to the judge, it's in the transcript, to hear this issue, correct?
To hear this issue in relation to the parties' ongoing custody dispute. It was not to hear the issue in relation, he was not granted a hearing as to the immediate risk to the child that he alleged in the petition. He was not granted a hearing as to that. And in fact, as I noted in the record, there were multiple misrepresentations made in that other proceeding. Nothing
You say
took
other
place
proceeding,
there.
what do you mean? The
Probate proceeding. There were multiple misrepresentations made in the record. There was no relief given to him, no protection for, excuse me, I apologize for stating the child's name, no protection given for, I was differentiating between the 2 children in the case in my mind. There was no protection given to the child, and his concerns continued, and injuries, as he noted on July 2nd, there were 3 separate injuries that he had seen, and he noted his child's behavior was continuing to regress. He also noted in his petition that the child's social worker had returned from vacation and specifically addressed with him whether or not he felt the child would be safer in the custody of DCF.
Are you arguing that the juvenile court judge lacked the power to defer to the probate judge, or that deciding to do that in this case was an abuse of discretion, or I guess both, you could argue?
I'm actually arguing both, because first, under Chapter 119, the preliminary hearing that he had before, the emergency hearing that he had before the first judge was a determination. That judge could have determined. I think that first judge absolutely had the power to do what you've just mentioned, Justice Ditkoff, and say, I don't think this is appropriately here in the juvenile court. It appears that you've already gone somewhere else. That court is going to have to resolve this. I don't find that you have laid out a claim sufficient for us to move forward. But that is not the determination that was made.
Your argument, right, am I correct, is that once a petition issues, that a judge has to hold a hearing?
Even if
Before
that hearing is
before
about the sufficiency
dismissing.
of the petition. I have always believed, and I know many arguments are made generally by the department, that under care and protection of Lillian, you cannot deny the department when they're the petitioner, regardless of whether there's a probate proceeding.
So let's
You
assume,
cannot
let's assume that a contentious neighbor files a petition to take the child of their neighbor into, custody of DCF and says under penalties and, pains and penalties of perjury, something that enacts danger. Is the judge is required, you're saying, to have a custody hearing in that situation?
No, what the judge is required to do is to, at that emergency hearing, assess the
Right.
sufficiency of that petition.
It's sufficient. I mean, the petition on its face shows danger. So the judge has to hold a hearing, right? You're saying?
I think the judge does have to, I think that's what the
And then
statutory
after
scheme
it's
is.
denied,
Absolutely.
And then has a hearing, finds out these claims aren't worth anything. And then the neighbor files another one, making the same basic claims. Judge still has to hold an evidentiary hearing?
Well, I think that the second judge reviewing that petition, in theory, would have available the information that exists in the record. that
But
it
the
was
petition's
previously
sufficient on its
unsubstantiated.
face. What else can you, so if you think, what can you consider besides the petition on its face in determining whether you have to go to a hearing?
We're talking about the first hearing, not the second.
No, so we had a hearing,
Yes.
and you
At
said they had to hold a
emergency
hearing the first time. So neighbor files a new one. Yep, still seeing them abusing the child. So does the judge have to hold an evidentiary hearing on that one a month later from the neighbor?
I think there's so many variables to that question, but I would say, basically, again, the petition, if the court determines at that hearing, rises to the level
Yeah, let's say it does.
of abuse,
On its
then
face.
the court, if the court, that would be for the justice to determine whether I believe that it does. If it does, then you issue the petition, and then you have another hearing. And then, I mean, obviously there are
So as
other-
long as your neighbor is willing to write a petition that on its face shows abuse, they can they have a right to have an evidentiary hearing on your custody, every month if they want.
That's
how
what
it
the
works?
statutory, I mean, you can change that. You don't have to make it a
Well,
neighbor.
no,
You can make
I
it
guess my next
DCF.
question is that
Sure.
constitutional? I mean, considering that the parents have a liberty right to custody of their children, is a statutory system where any person can require an evidentiary hearing on whether you get to have your child, as long as they can do a sufficient petition whenever they want. Is that constitutional under the 14th Amendment?
Well, there have certainly been challenges to the constitutionality of Chapter 119, Section 24, and it has been determined to be constitutional. And I understand that, Your Honor, it's an excellent question because there is this avenue for harassment, but obviously there are other mechanisms people can use if they're being harassed in that particular manner. But respectfully, I think you can take that same analogy you're using and make it DCF. Is there anything that prevents DCF from filing a petition, putting whatever they want in that affidavit, getting a hearing, forcing parents to come in and defend themselves? They lose. Anything that prevents them from doing it again in a month? And the answer is no. And DCF does it all the time. And DCF takes the position that once we get past that ex parte hearing, with the affidavit could be filled with nonsense, could be filled with absolutely.
Yeah, but I'm not sure we're going to accept that argument either. I mean, just because DCF argues something doesn't make it the law.
No, I agree with you. It doesn't make it the law. But my point is that the statutory scheme, I wasn't expecting a constitutional discussion about whether 119 itself was constitutional, but the case that addresses the constitutionality of Chapter 119, Section 24, specifically goes into the fact that at its core, this is a child welfare proceeding. At its core, this is about protecting children. So while it may infringe on people's rights, while it may force a parent to come forward and have to defend themselves, because at its core, it's a child welfare proceeding, at its core, we're concerned about the safety of children, the balancing of the parent's constitutional right to their relationship and custodial relationship with their children is effectively balanced by the preliminary hearing by the emergency hearing and by the preliminary hearings, which are required by statute. And the problem we
So-
had here was we never got there.
Your time has expired, but I do
Yes.
have another question.
Sure.
What are you asking us to order the juvenile court to do now?
Conduct a hearing. Conduct a hearing.
On what? On the petition that was filed now, it's been almost a year. It was a petition alleging an emergency at that time. So what is it that the juvenile court can do now?
It was already determined, there was a petition alleging an emergency, but the first judge determined it was not an emergency and scheduled it for a Section 2526 hearing. So it was not what we call a 72-hour hearing where there had to be a hearing within 3 days. It was set out further. There was, for that second type of hearing, where the judge still has the ability to give custody to the department or to a parent. But respectfully, as I mentioned earlier, not that this is technically before this court on the record, there is still no ruling from the probate and family court. And my client's concerns still continue. And had the court conducted that hearing and made a determination as to what that child's risk was, that's one of the reasons the Chapter 119 proceeding has the protections that it does and has the rules that it does, is because it moves quickly. You do not wait a year for a ruling on a Chapter 119 proceeding, but that is what has happened in the probate court, which is why this was the appropriate vehicle.
Okay, thank you very much.
Thank you.
All right, I understand the parties, the appellees are splitting their time, 6 minutes for the mother, 6 minutes for DCF, and 3 minutes for the child?
Yes.
Okay, thank you.
Good morning, and may it please the court, Kara Shayat for the mother. I want to reframe this. This case is about the trial court's inherent authority to dismiss a complaint or petition that's been filed by a party who is mid-trial in another court and who announces his intention to abuse the judicial process. He's unhappy about the way things are going in probate court. He claims that the judge isn't reading his filings, so he decides to file in juvenile court. And I just want to note that the standard of review is abuse of discretion. Father argues that it's de novo, but this wasn't a dismissal based on the sufficiency of the petition. This was about, again, a father who...
But isn't he saying, look, I tried? I mean, these were serious allegations, right? And the
Yes.
mother was actually charged criminally, there were injuries, so it wasn't insignificant, right? And so clearly he had concerns about the child's welfare and remaining with the mother, right? And so he
That's right.
raised those concerns, tried to the probate court without an existing open case, and then was not getting heard, essentially. So it is a different case, isn't it? I mean, and I think Attorney Lamont is correct. The juvenile court has exclusive jurisdiction over 11924 petitions. So talk to me about...
Well, so first I just want to take issue with the premise. He filed on May 6th.
Right,
an
and it was
emergency motion.
July.
But it was heard on May 7th, so that endorsement is that paper endorsing the hearing on May 7th is in the record, was attached to the juvenile court petition. And also, then if you look at the docket, I think it's paper 303, this is June 27th in the probate court is when the probate court judge orders this additional day. That's right. And I mean, if you look at that paper filing, the judge's order, what she was going to hear was the parental fitness, substance abuse issues, physical abuse.
The same issues. that
Exactly
father-
the same issues. That's what was going to be heard in August.
Here's what concerns me. Probate judges are really good at figuring out which parent should have custody and how that should be split. I mean, that is their core competence. And though they can send children to DCF, that isn't really what they're experienced in. And a juvenile court judge is very skilled in figuring out when children should be put in DCF custody. So considering that reality, is it really, when the question is, should the child be in DCF custody, is it really sensible to send that to a probate judge who has the power to do it, but not really the experience in adjudicating that kind of issue.
But then there's another mechanism. There's the request for an interdepartmental transfer and a consolidation of the CNP with the probate case. That can happen. That request was never
But wouldn't
made.
that just replicate the problem? Calling the probate judge also a juvenile court judge doesn't change her expertise.
But you can do it the other way around. You can have the interdepartmental transfer happen to the juvenile court. I've had that happen. That request was made.
After 2 days of trial without factual findings? I mean, I don't know how that would work.
Oh, no, but there are, I guess what I'm just saying is that I appreciate what you're saying, Justice Ditkoff, that probate judges may rarely be in a situation where they invoke the authority to vest custody in DCF, but the power is there, and you can imagine a probate court saying, you know, a pox on both your houses.
Right, and so we've been focused a lot on custody and removal of the child, right? But in 11923, A3 does give the probate judges the ability sua sponte to place a child in
DCF custody.
custody. But a 11924 petition isn't just about custody, right? Because there are many, many instances where it's really a care and protection petition. And so the allegations, you know, the 4 different grounds, right? So it isn't just about removal. In fact, there are plenty of cases where the department or the petitioner doesn't even seek removal, but says, you know, we are concerned about this family, we're concerned about this child, we need court oversight.
Right.
So what do you say? Because the father, it appears to be, I think, saying, well, at the very minimum, this is the relief that I was seeking, which is not, is that something that the probate court can give?
Well, wait, I'm sorry, I'm not understanding. So is it you're saying that the probate court wouldn't be able to grant the relief that he was seeking?
That's my question, really.
Yeah, no, I disagree. I mean, and certainly even though 23A is written that the probate court can sua sponte, certainly he could ask the probate court judge to invoke that authority. But if I could make one just, did I just lose my, just that Judge Hennessy at the hearing did note that she'd been out sick the day that the emergency petition came in, which suggests to me that she was thinking if I had been actually not out sick, I think it's at RA 88, she says that somebody else was sort of sitting in for her. And the suggestion is that had she been the one who actually had been there and gotten that, it's not clear that the petition would have issued. Had these issues, I'm not sure, but she just did just note that. We don't know that. We don't know that. But I do think that there are other remedies, and the father didn't take advantage of the other ways, again, to do the interdepartmental transfer, and again, it can go to the juvenile court. And just again, at the end of the day, he was mid-trial. If DCF had come forward, DCF filed a CNP, then you've got an organization coming in with presumably good faith, and this would have been a very different case. But this is the party who's making all of these motions in multiple courts, and I think the court was well within its inherent authority as a discretionary ruling to dismiss. And unless I know my time is up, so unless you have more questions, I'll let DCF carry the ball forward. Thank you.
May it please the court, Jeremy Bayless for the Department of Children and Families. I guess I'll sort of pick up where my sister left off and go back to one of the points that Justice Ditkoff made, which is the separate core competencies between the juvenile court and the probate court. And I think in the, were both of these cases sort of filed concurrently, it may well be the case that it would be preferable, not necessarily mandatory, but preferable to have the juvenile court hear a care and protection proceeding. But that's not the facts that were here. This was a filing that happened in the middle of a trial, and father wrote in his affidavit that he was filing it because he didn't feel like he was prevailing the way that he wanted to in the probate court. He filed it pro se. He is not disguising the fact that he is filing in the juvenile court because he doesn't like how his trial's going in the probate court. And under those circumstances, the juvenile court is not required to assist a parent in circumventing the judgment of the trial that's already ongoing. And so what's before you is that sort of narrow set of facts. It might well be different.
Right, but we got to write it up.
Well, yes. And I think that the write-up can be limited to the facts that are actually before you, because there are certainly circumstances where if specific facts were different, the exercise of discretion is different, and the outcome is different. But here, we have a parent very clearly forum shopping, and whether or not that forum shopping is for honorable, understandable reasons, they are still forum shopping. In courts in Massachusetts have consistently found.
So, I can see that a probate judge can order DCF to take custody of a child.
Yes.
But can a probate judge cause DCF to give services to a child? Or does that only happen in a, juvenile court proceeding?
Once the department, well, I guess sort of twofold. Once the department has custody, we are obligated to make reasonable efforts to promote reunification. That obligation flows through. So your Rashida motions, all of the implements to enforce that are available. We're also bound by our own regulations to make services. We provide services to families when we don't have custody. So they still have the ability to act there. The probate has the ability to assign a GAL and is to provide oversight.
So really, under 11923, if you have custody that way, or not even custody, but I think that it's worded responsibility, I think, is what, right, of the department to provide foster care. That's what 11923 is. It gives the probate court the ability to get DCF involved. So I think you're saying, and I'm just reading it right now, all of those things determine child's abode, medical care, education, control visits to the child. So essentially everything that you would be doing once you're involved in the probate court through 11923 is the same.
Yes.
You could be doing, handling the case and monitoring it, supervision and everything, and provision of services as you would in the juvenile court under a 24.
Yes.
If the probate court issues an order under Section 23, giving responsibility to the department, does the matter ever go to juvenile court after that? Department go to the juvenile court and file a CNP at that point?
I haven't thought of it that way. Not on its own, I don't believe, but I don't
Does the
suppose
probate
there's
court
something-
order the department to go file a CNP in juvenile court?
I'm not sure. I mean, I certainly can. I don't know whether or not that order would be enforceable, but if I don't know that the department would also.
No, you don't know as a matter of practice if that's what happens?
I don't. I do know that when the department is in a position like what father alleges he was, when the department is in a position where it has to file a care and protection when there's ongoing probate court matters, there is interaction. I'm not one of the attorneys
So
that
what
does
kind
that.
of oversight is there over this order granting responsibility of the child to the department? The order issues and then that's the end of it.
The oversight would be through the probate court. And so then
I mean, do you know what that looks like? I mean, it's brand new to me, so.
Not personally, but I cannot, obviously the court should not rely on my personal, but I cannot imagine a world in which there are relief mechanisms that are available, but the probate court does not permit parents to file the same level of motions. That if the department is not making reasonable efforts to promote reunification, that there would not be the equitable authority under Rashida and under the respective statutes to file a motion to ask him to do that. Father, if he had taken this to the probate court judge who was familiar with the case, who also was...
He did. He tried, right? He filed the motions.
He did, and I would argue that is, this was not decided on the merits, but
Well,
that
there was
is...
an additional, actually, it hasn't yet been, from my understanding, but
Yeah, I'm sorry.
It was litigated, correct?
The juvenile court,
sorry.
the denial on appeal was not decided on the sufficiency and the merits of
Got
his
it.
actual complaints. But it is certainly telling that he brought this to the court who was familiar with the parties and familiar with their behavior and their allegations and presumably been making credibility determinations, that the probate court did not allow his motion when he received a hearing on it and has not swiftly ordered any action after a scheduled court date for the purpose of taking evidence on this very issue. That's not really dispositive of the appeal, but there's a reason that the judge, who is familiar with the parties, familiar with the facts, and familiar with the development of the case for years, is in a better position to evaluate new evidence on that matter. And I would argue that that is also, as is pretty clearly said in his affidavit, that's the reason father was looking for a new judge. So I'm happy to answer any additional questions, but I do see my time is up. Thank you.
Thank you.
Good morning. May it please the court, Attorney Robert McCarthy for the appellee child. From the child's perspective, this case is not about a simple motion to dismiss. It's about whether he was going to be dragged into a second courtroom when the first courtroom was already deciding his life. He's only 4 years old. His parents were involved in an ongoing probate court custody decision for it was at that time about almost 4 years. And the probate court judge was familiar with the family, familiar with the history, familiar with the parties. And she was actively managing this conflict for years. The conflict grew so intense that on June 27, 2025, the probate court judge issued an order stating that the parties could file no more further motions or pleadings without her express written permission. What does the father do? 2 or 3 days later, he walks into the juvenile court and files a care and protection petition claiming an emergency. That emergency, seen in that way, the juvenile court judge made a discretionary decision to prevent the child from being dragged between two courtrooms. Look at the timeline. The May 25th, 2025 incident the father describes as an emergency situation was already 2 months old at the time of the juvenile court preliminary hearing. It's a year old right now. But DCF investigated that May 25th incident. They were involved with the family and they opened a case, but they did not seek removal of the child from his placement, and that was with his mother. The child knows where his home is, and that is with his mother. And he's described in the record as bright, articulate, energetic. He does want a relationship with his father, but he knows where his home is. And that's not just a legal position, that's a child's lived reality. And this appeal asks whether the system should add more chaos to that reality. And for the child, the answer is no. He's looking for stability and consistency, and the juvenile court judge protected that right to that consistency. Chapter 119 is not a forum for parents dissatisfied with a probate court decision. It is a shield for children in danger, and the juvenile court judge correctly refused to turn a custody dispute into a care and protection case. And so if there's no further questions, we, for the reasons stated here, appellate argument, and for the reasons stated in our brief, we would ask that this appeal be dismissed.
Okay, thank you very much. Thank you all. The case is submitted. The next case is Paul Eng versus CHEN'S Food Enterprise, Inc. and another, number 2025 P1222.
Good morning, Your Honors, and may it please the court. My name is Leonard Zide, and I represent the appellant, Paul Eng, trustee of the 100 Norfolk Street Realty Trust. We're here today on commercial lease problem, summary process. The lease was triple net, which meant that the tenant was obligated to pay base rent and his share of operating costs and associated costs affiliated with his premises. The case is now based upon the fact that the appellate division reversed the judgment that was received by the landlord based on the fact of claim preclusion, but claim preclusion does not bar the recovery of rent that did not exist at the time that the first action was dismissed. There were two cases. The first case, which the record calls CHEN'S Food 1, was litigated in October of 2024. That case was dismissed by the court for failure to comply with a procedural requirement in the lease that not only did you have to file a notice to quit, you had to file a second notice of termination.
And that was a case in which you asked for about 20 months of rent, as well as possession.
21 months of rent.
21? Okay.
Correct. And what happened, CHEN 1, we calling it CHEN'S 1, which was the first case, sought 21 months of rent plus additional rent. The complaint was for $193,581, which included 21 months of base rent plus additional rent that made up the difference between $189,000 and $193,581. That case was dismissed on procedural grounds. There was no adjudication on the merits of the rent. What happened? Wasn't adjudicated. CHEN'S Food 2 was filed in February of 2024. It was filed, the rent default that was included in CHEN'S Food 2 was the month after CHEN'S Food 1 was dismissed.
But it was for the same back months
No,
at the first complaint.
It was not.
I don't understand that. How was there $198,000 of new rent after the first dismissal?
There was only $11,670 of new rent, but the claim
So is the
included-
judge, is the damages award wrong then? Because you were awarded $180,000. Should that be reduced to the $11,000?
Your Honor, since the rent wasn't adjudicated in CHEN'S Food 1,
No, CHEN'S 2,
CHEN'S 2,
you're telling me that the only new rent is the $11,000. So
the
why
only
is there a
rent that wasn't
judgment?
included in the first claim, correct?
So there's definitely money that was included in the first claim that's in the judgment at issue, right?
Correct.
Okay. Okay. Sorry, I thought you were arguing differently.
Oh, no, that's fine.
If that's what
But-
then I'm with you.
So what happens is CHEN'S Food 1, dismissal was entered on the docket January 30th. On February 1st, the tenant then defaulted again, non-payment of rent. On February 5th, a default went out.
And just to be clear, that's because at that point, the tenant owed not just February, but all the back rent they hadn't
Correct.
paid. Okay.
However,
And is
so the
your
new
argument that claiming an additional month of rent resurrects everything as a matter of claim preclusion? Saves everything from claim preclusion? Or are you saying that at a minimum, your client should have been allowed to proceed on the claim for that extra month of rent?
Since the rent issue was not adjudicated, and that was in the order by Judge Fiandaca, the parties were the same, the issue was the same, non-payment of rent, but the difference between 1 and 2 was that CHEN'S Food 2 included a month of rent that was not.
And what is the effect of that? What are you arguing is the effect of that additional month of rent that you're claiming?
You can only preclude issues that could have been litigated in the
So
prior
my question
claim.
is, are you saying just that extra month of rent is not precluded, or are you saying the whole thing is not precluded because you're claiming an extra month of rent?
We're saying the whole thing is includable.
Why, as a matter of claim preclusion, would that be right?
Because the trial judge specifically did not rule on the issue of rent, unpaid rent. It
Okay,
was
but then
unadjudicated.
if that's your argument, which might be a good argument, I don't know why the extra month of rent matters.
Well, that gets us beyond claim preclusion.
Yes.
Because then you would have the same month's rent, you'd have the same claim. But there are two different claims. One complaint seeks 21 months of rent, and one seeks 22 months of rent. It's an additional
okay.
month.
Why would it be a problem if the second complaint only sought the 21 months of old rent?
That
would
would
that
be
be-
precluded
Why?
because, in accordance with 41B3, because it was adjudicated without prejudice, it could be deemed as a merits-based decision. But it wasn't. The judge went out of his way to state on the record that it was because the
It was
rent
procedural defect,
was a
right?
procedural defect. It wasn't a factual defect, and because it was dismissed on a procedural problem, the second termination
It
agreement.
just seems to me if you're right about that, you don't even need an extra month of rent. The fact that he doesn't pay back if he paid back all the old rent, you couldn't get possession. But if he doesn't, regardless of whether he paid the new rent, you'd be able to try to evict him on the basis that he still owes you $180,000.
Well,
Am I missing something?
I think so. 239, Section 7 allows landlords to pursue recalcitrant tenants. Specifically was drafted because under a lease that runs for years, a tenant can default more than once. So in
So
accordance
why
with-
does it matter that there's an extra month of rent?
Well, but the extra months of rent takes us out of HECOC. It takes us out of claim preclusion.
As a matter of claim preclusion, well,
So the new rent, because claim preclusion precludes those things that could have or should have been litigated in the first
right, and that would include the
That would include
21 months of rent.
the
So I don't know how the
21 months
extra
of rent.
month of rent, as a matter of claim preclusion, can resurrect the past rent. I don't understand that as a matter of claim preclusion.
Well, the appellate division ruled specifically that the CHEN'S Food 2 include the same people, the same issues, and the same month's rent. It didn't. It included also the February rent, which didn't come due until after the first case was dismissed. So you can't preclude a new default.
Can we talk about the statute? 239.7. So we have said that that statute does not bar application of issue preclusion,
Correct.
okay? Are you aware of any case that has discussed this in the context of claim preclusion?
Well, aside from Bowie and Ma, and aside from the Santos case, and aside from HECOC, those cases that deal with preclusive preclusion of issues that should have been litigated in the prior action, because they're the new rent, the $11,600.
Now, my question's very narrow. Are you aware of any case that has addressed whether the statute 239.7 bars the application of claim preclusion?
I am not, Your Honor.
Okay.
So what we have is the central, the factual error, Your Honor, is that the February default could not have been litigated in CHEN'S Food 1. If it couldn't have been litigated in CHEN'S Food 1, it should not have been precluded, because after occurring...
All right, but so the problem is, you seem to have lost on the February rent. The judge didn't find the February rent was owed and awarded money for other months, earlier months.
That's correct.
So once you lost the new thing, why aren't you claim precluded on all the old things?
Because the judge's order only ran through January of 2024. The order itself actually spelled out the months that weren't paid. And so because he was silent, Judge Fiandaca was silent as to the February rent, it was dispositive of the fact that the order only went through January of 2024. Since that case was docketed, dismissed on January 30th, and his order was specific. He specifically laid out the months. The last month he referred to was January of 2024. The new rent, February, was not included in his order.
Right, but in the judgment under appeal, it's awarded only through October 2023. The judge specifies which months weren't paid, and the last one is October 2023. You didn't win on February in front of Judge Fiandaca the second time. So why isn't the preclusion on the damages we do have?
We did win in front of Judge Fiandaca and CHEN'S Food 2. The first case, October, we did not.
So where did he say that February wasn't paid? Because I didn't see that. I saw him listing the months that were unpaid, and the last one's October 2023.
Your Honor would look at the order, memorandum of decision, it's at the addendum on page 74. It says monthly rent was paid through March of 2020 when COVID pandemic struck. No rent was paid for April 2020 through August 2021 inclusive. Rent was paid in September 21 and November of 2021. And if you go through all of it, then he says rent was paid again in November and December of 23 and January and 24.
Right, but where does the judge say rent wasn't paid in February 2024, or that he was awarding recovery?
It's silent. It wasn't adjudicated.
And when I add up all the, maybe I did the math wrong, but when I added up all the months in that paragraph,
Yeah?
and multiplied it by 9,000, I got the recovery, not leaving an extra month to be added to the recovery.
The rent, if the court would refer to the complaints themselves, the complaints attached an accounting that shows exactly which months were paid. There were 21 months in the October complaint. There were 22 months in the February complaint. The February complaint includes another month rent that the court did not adjudicate and cannot be precluded. That would be unfair. So since the
Okay,
case
so let me try it this way. I add up all these months in this paragraph, and I get 22 months.
Your Honor, I can only direct the court to the complaint itself, which
Well,
has an accounting.
the complaint is not what the judge found. The judge found what he found, and he found 22 months in this paragraph. When I multiply that by 9, I get 198, which makes me think that the judge was awarding rent only for those months and not for February of 2024.
And he did not award for the additional rent. We asked for additional rent as well.
Right, so he only awarded for the months that were at issue in CHEN'S 1. So why?
CHEN'S 1 was 21 months. It only ran through October, Your Honor. That was, understand that CHEN'S 2 was filed 3 months later. And so there was rent paid after CHEN'S 1 was dismissed. But then there was a default again after the trial. The trial ended, and then in CHEN'S 2, it included a month that was not litigated in CHEN'S 1. So by depriving the landlord of rent that was not litigated or couldn't have been litigated, because you can't litigate an issue that's not in existence. February was not in existence.
All right, wait, when was the trial in CHEN'S 1?
January 30th. Oh, no, it was docketed. It was actually before that.
Of what year?
The trial in CHEN'S 1, I don't recall the exact date, Your Honor, but it was prior to that time.
Prior to what time?
It was prior to the trial in CHEN'S Food 2.
I figured that out.
The judgment was entered on the docket on January 30th. But the trial date, the court would look at. All right, the trial date for the case was entered in October 30th of 23. If you figure that under the old summary process rules,
All right, so the case was entered on October 30th, 2023. The
Correct.
trial must have been after October 2023.
correct.
So why couldn't all the rent through October 2023 have been adjudicated in the first trial?
Because the trial was continued. There was a continuation, and the trial did not continue until January 4th of 2024. That's what it was. We started, and then it continued in January. So,
But it didn't start in October, right?
No.
It had to start after October.
Correct.
So why couldn't the trial adjudicate the rent through October 2023, all months that had happened before the trial started?
It adjudicated all the rent through January, Your Honor. It adjudicated in the order because
Okay, that was what I was saying, that the first case, all the rent through October 2023 was at issue, and that's all the rent that supports the damages in CHEN'S 2. So why isn't that precluded?
because your facts are not correct. Your
Which
Honor,
one's wrong?
respectfully.
Which one's wrong? I mean, really, please.
So, notwithstanding that the first complaint for $193,000 included rent through October. The trial didn't conclude until several months later. And at that point, the judge included the months after October where rent was paid. So we entered the complaint in October. They paid November, they paid December, and they paid January. The judge included that in his order and decision. The second trial, and Your Honor, that case was then dismissed because of procedural problems. The court did not adjudicate the rent issue. But in CHEN'S Food 2, it included a month's rent that was not in existence. So notwithstanding that the file was...
What do you mean by included? What included?
It wasn't in existence.
No, what you said something included it, the February rent. What included February? I just didn't hear the word you said.
The claim preclusion precludes things that should have been tried in the earlier action.
I understand, but you said something included February. What was it that included February?
CHEN'S Food 2 included rent that was not
Complaint included, your case included, or the judgment included?
The case was about another month's rent that was not litigated in CHEN'S Food 1. And because it wasn't or couldn't have been litigated, Your Honor, it is not barred by claim preclusion because you couldn't litigate it. It wasn't in existence. So since it wasn't in existence, and when CHEN'S Food 2 came to fruition, it was subsequently litigated by the same judge, Your Honor, and because he only included 22 months of rent, which is $198,000 and not the additional rent, he awarded a judgment of 22 months total of base rent, which did not include the additional rent.
Okay, your time has expired. We'll have to leave it there.
Thank you, Your Honor.
Good morning, and may it please the court. Attorney Joshua M. Daniels for the defendants' appellees, the tenants. I'm fighting a cold this morning, so I'll do my best to make myself heard. The court should affirm the appellate division's decision for three basic reasons. The first is that the landlord's lead argument, the one that you just heard about there being two different rent claims between the two cases, was not properly made to the appellate division. It was raised only on reconsideration, which was too late, and so I think it's forfeited for purposes of this appeal. The second point is that it doesn't really matter whether it was properly presented to the appellate division or whether it's preserved because, and the prior discussion already alluded to some of this, as I read the record, and in particular as I read Judge Fiandaka's findings, the only claims that the landlord actually won in CHEN'S Food 2 were the same ones that were asserted in CHEN'S Food 1. I honestly do not know why we are talking about February 2024, because Judge Fiandaka did not find that that month was in default. And I think the fact that it wasn't adjudicated and that it wasn't awarded suggests pretty plainly that it wasn't in fact actually at issue in CHEN'S Food 2. But even granting the assumption that it was, the point is the only claims that they won on were the ones that preceded and thus were baked into the disposition of CHEN'S Food 1. And so the only question is, was the disposition of CHEN'S Food 1 by involuntary dismissal a final adjudication on the merits with claim preclusive effect under 41B3? And I think a straightforward reading of 41B3 answers that question, yes.
Would you agree with the proposition that Chapter 239, Section 7's purpose is to exempt summary process not from principles of finality, but only from the normal rule against claim splitting?
Yes.
Okay, so in that case, how can there be normal res judicata in summary process on claim splitting?
So I would point you to the SJC's decision a few years ago in Jinx versus Credico, which discussed how claim splitting and claim preclusion are related concepts, but they are not the same. As best as I can understand what Section 7 was trying to do, and this is sort of taking a look at the statute at the time, like way back when summary process was new and Section 7 was included in that. Back in ye olden days, summary process was a special purpose litigation mechanism. It was only about possession, and possession was basically the only thing you could litigate in there. You could not litigate money claims at all. Those came later. And so I think what Section 7 was trying to do was preserve your ability to bring a different summary process case on a different ground.
Why does it have to be different? My understanding, correct me if I'm wrong, is that it's a quite common occurrence where a landlord makes some sort of there's some technical defect, say, in the notice to quit, and so the summary process action is dismissed, and then the landlord sends another correct, adequate notice to quit and can bring a second summary process action based on the same ground as the first. That's my understanding, that is actually pretty common. Am I wrong?
I don't disagree that that's fairly common. I think in that in those circumstances, because 41B3 applies in summary process cases, what should be happening is the judge should specify in his dismissal.
He did specify, didn't he?
In the order itself. Here he did not in the order itself.
Why is that necessary when the statute says the judgment shall not be a bar to any action thereafter to recover the land or to recover damages? We'll get to the damages next, but to me, the plain language of the statute authorizes successive summary process actions.
I think that would be an absurd result. I think
Why?
this is because I can't imagine a system of litigation where like literally nothing sticks no matter what happens.
Well, what sticks is the possession. So a judge finds that the landlord isn't entitled to possession, and summary process cannot order damages in that situation.
Correct.
So why is it absurd to say that now once you actually do things correctly and entitled to possession, you can get the back rent due? It seems like the absurd thing would be to say that if you make an error in the notice of default, that you forfeit all rent due at that point. Why isn't that the absurd thing?
I mean, I think, getting back to sort of what I think Section 7 was trying to do, it was trying to preserve your ability to bring a new default and get possession based on a different ground, not the one that you litigated before, and not the one that you lost.
That's not what it says, okay? So it's not that nothing will stick, because we have said that issue preclusion does apply despite the statute. So if a landlord brings a first summary process action, loses on the merits, on whatever ground it is, unpaid rent, what have you, issue preclusion would bar a successive action. But I don't see what's absurd, as Justice Ditkoff said, that where a landlord, some of whom are unrepresented, makes a mistake, that they can't do it again. In the meantime, the tenant retains possession the amount of time it takes for the landlord to do it again and to bring a second action on the same ground. I don't see why that's absurd.
I think to follow the rules, and particularly Rule 41B3, the judge is supposed to specify in his order of dismissal this is without prejudice. Otherwise, the assumption is this is going to be with prejudice unless we fall within one of the magic circles
Why does
of
the
41B3.
rule, if there's a statute, why do we look at the rule? I mean, why are we not just limited by the plain language of the statute?
I mean, the other statute that we have to talk about is Section 3 of the summary process statute, which says that if the plaintiff becomes non-suit or fails to prove his right to possession, then judgment enters for the tenant. I think my reading of that sentence of Section 3 is if the plaintiff loses on possession or the case is dismissed, then the tenant is entitled to judgment. The tenant wins the case. And I think, as I read Section 7, it doesn't prevent you from coming back in on a different lease violation, say like you didn't pay rent in January and then you don't pay rent 3 months later in April.
Let's dig down on that. So let's put aside the damages for a second, because I think you're challenging the possession, or you're not challenging the possession judgment.
We're challenging, we challenge both damages and possession because the possession was based on the failure to pay rent.
So what's wrong with the possession? We get to February, and your client owes the rent for February, but he also owes the $198,000 back rent still. So why isn't that a default that, regardless of whether you can recover the damages, supports an eviction and judgment for possession?
I mean, this gets us back to where I started, which is I don't think the landlord won on February. I think I don't think February was actually at issue.
I understand. No. Let's say the February rent is paid, but when you get to February, you don't just owe the February rent. You still owe $198,000. I mean, if I have rent of $1,000 a month, and I miss my rents on January, February, and March, and the landlord doesn't give me a notice of default, I get to April, I don't owe $1,000, I owe $4,000. So on February, your client owes the new rent plus $198,000. So why isn't his failure to pay that a default that justifies eviction?
Because the prior rent was claim precluded in this case by the disposition of CHEN'S.
Well, but claim preclusion doesn't mean it's not owed, right? It just means it can't be sued for, right?
I mean, it can't be sued for. I suppose there could be, I think I recall some old cases about like the difference between the remedy and the obligation. I think in practical terms, though I think in practical terms, if you have no remedy, I'm not sure what it means to say that the rent is still owed.
There is a remedy, because if you don't pay your back rent, you get evicted. So why isn't that the remedy for not paying the $198,000 that you owe?
I mean, the eviction was based on the
eviction was based on $205,000. So I mean, it was definitely including that.
Right. I'm talking about Judge Fiandaca's judgment. The judgment of possession was based on the finding that 22 months of rent, all of which were claim precluded, had not been paid.
Right, but why is that? Why is the claim preclusion on recovering that rent a bar to the landlord evicting when the rent is still owed? I mean, it seems to me if your client had paid in February the $198,000 plus the next $9,000, there's not a thing the landlord could do about it. Would have to let him keep going with his possession for as long as he kept paying. But I don't understand why the debt disappears.
Because of Section 3 and the sentence that I quoted from Section 3, which is when the landlord becomes non-suit, which happened here, or fails to prove his right to possession, which he should have because he's suing completely.
It says the defendant shall have judgment, which he got. It doesn't say, and all debts to the landlord are erased.
Well, I mean, the tenant was entitled to judgment, and I think what we're talking about is the claim preclusive effect of that judgment.
And Section 7 says that judgment shall not be a bar to any action thereafter.
So I want to say a couple more things about Section 7 that I really want to leave you with as our time is dwindling. The first is, I don't think, to go back to one of your questions, Justice Shin, in the top half of the argument, I agree that that there is no case that has fully reconciled Section 7 with claim preclusion, even though there are at least 2 precedential decisions of this court that have still applied claim preclusion to summary process
without
judgments.
discussing the effect
without discussing the effects of Section 7. The other thing I would say is, I think those cases are precedential, their holdings, even if their rationale has some...
Well, are you talking about Santos?
Santos and Bui versus
Santos
Ma.
was a declaratory judgment action, so it raises the question whether that's a land to recover, action to recover the land.
Right.
Right?
I'm not sure if the same can be said of Bui versus Ma, which I need to go back and look at that case. The point I was making was, those cases are precedential and binding for the moment, even if they haven't been fully reconciled with Section 7. The other point I would make in terms of the absurd result is, issue preclusion is great in terms of issue preclusion solving a lot of absurdity in summary process. It does not solve everything, however, because one limitation of issue preclusion is that it doesn't apply if there was no actual litigation of the case. And over half of summary process cases are disposed of without actual litigation. I'm talking about agreements for judgment. I'm talking about default judgments.
I saw that argument. So
And
what,
I think
what would a successive action by the tenant look like in that situation?
I suppose it would be an action for a declaration that the tenancy continues.
All right, so then maybe that's not an action to recover the land, technically, within the meaning of the statute. A declaratory judgment for what exactly?
A declaratory judgment
and
injunctive relief to allow us to keep living there. I mean, that I can imagine ways of relitigating. If there is no claim preclusive effect, I can imagine a dissatisfied party coming back and being like, you know what, I don't really like my agreement for judgment anymore. Like, let's keep going.
I don't know if a court would have jurisdiction to issue an injunction ordering possession back to the tenant outside a summary process. I mean, I don't.
The other thing I would say is, I think if you were to hold that there is no claim preclusion for summary process judgments on the basis of Section 7, it would be very disruptive potentially for all of those dispositions that are not covered by issue preclusion. And if you were going to do that, I think this is possibly the worst case in which to do it, because this issue really was not well briefed in the landlord's brief, and it hasn't been. I mean, it wasn't terribly well briefed.
I don't know how much more there is to say, right? You have the plain language of the statute. There are no cases on it. Okay, I know you're running out of time, but I do want to ask you about the damages too. Okay.
Yep.
So Section 7 also applies to actions to recover damages, right?
Yep.
Okay. The problem I'm having here with the damages is that if this were an ordinary civil action, not a summary process, there would have been two claims, okay? One for possession, one for damages. The possession claim is kicked out because of the technical mistake made with the notice of termination.
Yep.
The damages claim would have survived, right? So the damages claim is swept out with the possession claim. So how, even assuming claim preclusion applies here, how did they have an adequate opportunity to litigate the damages?
Because, first of all, the reason why this case got kicked was their own failure to follow the provisions of their own lease. And they had experienced counsel all along. I don't think this is, while we might imagine other cases that perhaps are more sympathetic, I don't think this is one of them. But I think one thing that's been happening a lot this morning in the top half of the argument is there has been a continual conflation of the ideas of claim preclusion and issue preclusion. Because for claim preclusion purposes, it does not, what we're talking about is whether the claim was finally adjudicated or disposed of, not whether the issues that are baked into that claim were actually litigated and decided.
I acknowledge you might be correct in terms of the strict elements of claim preclusion, but we have to apply the statute, the plain language of the statute, and I do not see in there anything that says a successive action on a different ground. Right, so let's say you have a residential landlord who seeks to evict a tenant because of something that's interfering with the quiet enjoyment of the neighbors. Okay, let's say it's a very noisy dog. Okay, the landlord makes a mistake on the notice to quit, which happens a lot. Okay, there's some technical defect, and the first action gets dismissed.
Yep.
Your position is that the landlord is forever barred now under claim preclusion from bringing an action to evict based on the noisy dog?
My position is that the landlord is supposed to pay attention to how the dismissal is phrased, and I think—
So that is your position, unless the landlord knows well enough to say that under Rule 40, ask under Rule 41 that it says without prejudice, the landlord's forever barred.
Yes, because that is how and I think a lot of these problems, a lot of these practical problems are sort of an unintended consequence, perhaps, of Cambridge Street Realty, because if Cambridge Street Realty had gone the other way, if this had been considered a jurisdictional defect rather than a defect of the prima facie case, 41B3 wouldn't cause any of these problems. I think we're all stuck with what the SJC decided in Cambridge Street, and while it was good for landlords in some respects, and that the defense is that defense is waivable, this is the bitter with the sweet of that decision, in that they're in the same position as many other litigants, in that when the judge dismisses a case involuntarily, unless you are within one of 41B3's special categories, unless one of those applies, you have to pay attention, and the Zobel Treatise puts this very well. You have to pay very close attention to how the judge phrases that dismissal order, and you have to get in there, if the judge doesn't say without prejudice, in the order itself, not in a different case 5 months later, but in the order itself. And this order did not say without prejudice. You have to get in there and correct the order, maybe under 60B1, which they had the chance to do for 10 months after this. And if you don't do that, you may find yourself out of luck. And that just goes with the territory of litigation presumes, I think, that you're going to put your best foot forward. And the way 41B3's baseline works is you are not, when you're involuntarily dismissed, you don't presume that you get a do-over. You have to put your best foot forward, and you have to be on the lookout. Otherwise, your rights could be prejudiced irrevocably, and I think that's what happened
Okay,
here.
thank you.
Thank you.
Case is submitted. We will take our mid-morning break, and we'll be back in approximately 15 minutes. Okay, we'll proceed to case number 4, which is Reginald Miller versus City of Springfield.
Thank you, Your Honor. My name is Morris Cahaline.
I'm sorry, I forgot the case, say the case number. Case number 2025P 1070. My apologies.
Sorry. My name is Morris Cahaline. I represent the City of Springfield. In this case, the plaintiff was a Springfield police captain who brought claims of disability discrimination, race discrimination, and retaliation under Chapter 151B. The jury returned a verdict finding retaliation under Chapter 151B, but finding no discrimination. The jury verdict included a finding of $38,326 in lost wages, and that amount was exactly the amount that the plaintiff had testified was the difference between his salary as a lieutenant and what it would have been as a captain after he had not received a promotion in September of 2020. And the dispute centered around that September 2020 decision. At that time, the superintendent of police had decided, the assistant to the superintendent of police had retired. That individual was a captain at the time. The same individual had started that job as a lieutenant. And the superintendent hired a lieutenant for that position. It historically was a position that had never necessarily been a captain's position. It had been filled by sergeants, lieutenants, and captains. And in this particular case, she decided that the best person for the job was a lieutenant.
But the claim isn't about that position, right? It's about the promotion to captain.
The promotion?
To captain, right? The claim isn't that the city discriminated by not selecting him, the plaintiff, for that particular position, but that they discriminated by not promoting him to captain when the captain retired. Isn't that the claim?
Well, yes, that's true, but the contention of the appellee, I believe, is that at that point in time, Mr. Miller, or then Lieutenant Miller, was first on the captain's list under the civil service rules. And the contention was that because a captain had retired, the captain should have been replaced with a captain. As I noted, historically, that had not necessarily been what had happened. Sometimes the position was filled by a captain, but it had been filled by men or women of other rank.
So the question to the superintendent was, now right about this time in September of 2020, was there a vacancy for a captain position? Answer, yes, ma'am. And was Reggie Miller considered a position? I believe he was. So why couldn't a jury from that find that there was a vacancy for a captain position that he was in fact considered for and not given?
I don't think that there was any evidence from which they could.
Well, I just read you the testimony. Why isn't that testimony by itself evidence of that?
I believe that the plaintiff testified and agreed that the position in the past had been held by sergeants and lieutenants as well as captains. So there wasn't any dispute about that fact. There was no contrary evidence to that.
I don't understand.
What about what I just read? Why isn't that contrary evidence?
Pardon?
Why isn't what I just read contrary evidence from the superintendent herself?
I think you'd have to repeat what you read, Your Honor.
Okay. Right about this time in September of 2020, was there a vacancy for a captain position? Yes, ma'am.
You're quoting the superintendent?
Yeah.
I think the superintendent testified at some length that it was not a captain's position, regardless of that one snippet.
Isn't there a distinction between that position, the assistant to the superintendent, versus a vacancy for a captain? Is that not, is there not a distinction between those two things?
That's exactly what we're saying.
There is no distinction?
That it's not a position that had to be filled by a captain. It had not historically necessarily.
Putting aside the position of assistant to the superintendent, As a general matter, if a captain retires, does that not create a vacancy for a captain?
No.
It doesn't?
No, because the superintendent can decide at any given time how many captains there will be. She can decide to hire someone of lower rank because she wants that person in the job. She may not have the budget to be able to fill it with a captain if she did.
According to
Or
the
she might-
testimony
sorry,
that
go ahead.
Justice Ditkoff read, there was a vacancy for captain at the time that the previous captain retired. She chose not to fill it, and instead they waited a few months until the plaintiff was no longer first on the list to then post the position for captain. Why couldn't the jury infer from that that there was some illegal motive?
Because it wasn't a captain vacancy. And she has the discretion in which she can decide who would fill a position and whether or not it would be a person of rank. There are, at any given time, and there was testimony about this, a different number of captains. The fact that a captain retired did not mean, doesn't mean under civil service rules that you have to then hire another captain. And this position had been previously filled by sergeants and lieutenants, and in fact, the captain who retired had originally filled this position as a lieutenant, and then he was promoted to captain, didn't change his duties. So it's just not, that wasn't the way Springfield worked at least, and there was no civil service requirement that made it work that way.
Does this argument only relate to the portion of the award of back pay of $38,000? In other words, it does not relate to the $150,000 in emotional distress damages?
It wouldn't, except that in that case, and in all the other allegations about whether or not there was an adverse action, there wasn't sufficient evidence of an adverse action.
Okay, but if we agree with you, just hypothetically, that there was no vacant captain position in late 2020, that would not necessarily invalidate the emotional distress award. Would you agree with that?
No, it wouldn't.
Okay.
It wouldn't. If it were determined that some other action was an adverse action that was retaliation, in addition to whether or not there was a captain's vacancy, that occurred in September of 2020. Up to that point in time, the plaintiff had never made any complaint about discrimination.
But he had requested an accommodation. Why can't there be retaliation again for someone for requesting an accommodation?
Not the way Section 4 and subsections 4 and 4A read.
Okay, but the judge specifically instructed the jury, it is unlawful for an employer to retaliate against an employee requesting an accommodation for a handicapped, and you did not object to that instruction. So why isn't that how can you raise an argument now that that can't be a basis of retaliation claim?
In and of itself, the instruction isn't wrong. The problem here is he asked for an accommodation. He was given an accommodation. There were no complaints. He did not oppose any practice forbidden under Chapter 151B up until January of 21, months after all this had occurred.
But why couldn't the jury find that he was retaliated against for requesting the accommodation?
Because it just doesn't fit the statutory wording.
Well, but
But that's the instruction that you agreed to. So how can you come up here now after agreeing to that instruction and say that instruction is wrong?
Because it couldn't be retaliation under the statute if the plaintiff, as it was in this case, had been granted the accommodation and had never complained.
You can grant an accommodation and still retaliate for them asking. You can grant an accommodation and still retaliate because they asked for one. I mean, they're separate things, right?
It's theoretically possible, but in the case of
what is
I'm sorry.
No, go ahead.
Under Section 4, there has to be an opposition to a forbidden practice.
Mm-hmm.
That's not an issue here. The other section, subsection 4A, says that you cannot intimidate, coerce.
All right, let me try one more time. Why isn't your agreeing to a instruction that says the opposite of that, the end of it for our purposes? You agree to an instruction that says it is unlawful for an employer to retaliate against an employee requesting an accommodation for a handicap. So once you agree to that instruction, how can you come up here and tell us the statute does not allow that to be a basis of a retaliation claim?
Because in and of itself, the instruction is not improper. There could have been, if there had been an adverse action against him, if there had been, on his part, an action to oppose a practice, which did not happen, or if there had been intimidation, coercion.
Actually, let me try it a different way. Is there any place you raised this theory below? Because you didn't raise it in your directed verdict motion. So
Well, yes, I did.
your directed verdict motion said, in retaliation, he has not suffered any adverse employment action. You didn't say anything about the request for accommodation can't be the basis. Or if it did, tell me where.
Well, it was certainly in the motion for JNOV, Your Honor.
Tell me where in the motion for JNOV, because I looked at it.
Pardon?
Tell me where it is in the motion for JNOV.
I don't think I heard
I think
the question.
he's asking you to point out
Yeah,
where it is.
it's Record Appendix 1, pages 60 to 61. Tell me where you raised this argument in that motion.
I don't have the pages in front of me, Your Honor. I don't know.
I think
what
your colleague does.
It'll take me a bit to. No, I need the brief on the JNO. And I think the judge in his decision references that, but just puts it aside, doesn't really directly address it. Now, I will try to find the specific argument I made, but I did make it. Well, it would be from 77 to 79 of our brief. That's in the volume 1 of the record appendix. And
So you raised it for the first time in the JNOV motion, you're saying?
that particular finding, yes, that could well be.
So does it to preserve an issue to raise it not in the directed verdict motion, but only in the JNOV?
Well, I think the problem there is that the jury ended up making a finding directed, it seemed, in terms of the wages, only on the basis of the non-promotion.
Jury was doing what they were instructed, right? Didn't they? As Justice Ditkoff has asked, I think, a few times.
But it's a purely general instruction that is not incorrect. I don't think
But again, that you didn't lodge an objection to, correct?
Pardon?
You didn't object to that.
To the instruction, no. But again, one would have to anticipate that the jury was going to do it in that fashion, which I don't think would have been something that could have been anticipated. And the McLaughlin case that I had cited, I think makes it clear that you have to have intentional discrimination if you're going to make a finding under subsection 4A. And again, the individual in this case had been given the accommodation. In fact, he'd been given an accommodation that nobody else had ever been given in the known history of the department, being a sworn officer being allowed to work from home.
So why isn't the reprimand an adverse action when it expressly says it has or can be used to assess qualifications for employment, promotion, transfer, compensation, et cetera? Why doesn't that qualify as an adverse action?
The reprimand was never used with respect to...
It's put in his file. It expressly says it has or can be used for those to negatively affect your employment. So I'm having trouble seeing how that could not be an adverse action.
Well, the body case that I had cited says there has to be an actual tangible consequence, and there never was. It in fact didn't have a consequence that would meet either that standard or the standard under McCormick of being materially disadvantaged in salary grade or objective conditions on the job. Again, in that case, there wasn't any adverse action. I don't believe there was any other adverse action from which the jury could have made the finding of retaliation that it did. This individual was given extensive leave, was allowed to work from home, never missed a paycheck, and not only does that show that there was no adverse action against him, but in addition to that, I think, makes the finding of punitive damages inappropriate.
Your time has expired. We have your brief, so thank you very much.
Good afternoon, Your Honors. Tanny Saperstein for Reggie Miller. I would just like to, and I'm going to be really brief, it's clear and it's established in the Commonwealth of Massachusetts that Reggie Miller engaged in protected conduct. The first thing he did was request an accommodation, and although there's no state decision, there was actually a recent First Circuit decision, which I refer to in my brief, 2025, interpreting 151B. The request for an accommodation is protected conduct, and quite frankly, anything to the contrary wouldn't make sense, because if you can even accommodate the person but then retaliate, then that would eviscerate the disability protection in 151B and a request for an accommodation. He filed with the Massachusetts Commission Against Discrimination in January of 21.
The Declare case, what's the First Circuit case?
I'm sorry, the First Circuit case is referenced on page, I believe, 16. Give me 1 second, Your Honor. I had all this written down.
It's the main, is it the main case?
It's the case,
The Moore case, the really recent one?
Moore versus Industrial Demolition LLC, right. And it was under, even though it's a First Circuit case, it was under 151B. And then he also filed a supplemental MCAD charge for retaliation in November of 2022. So I think that this court should apply the Moore case, but I also think it's counterintuitive to say that requesting an accommodation isn't protected conduct. And if you look at 151B 4A, you're not supposed to retaliate for any person who has engaged in protected conduct, which is requesting a reasonable accommodation if you're
Can you talk to me about Section 4 versus Section 4A?
4A, yeah, it's confusing.
I'll just refer to it as 4A. And that you plead it under Section 4.4. Does it matter how we're analyzing it under Section 4 versus 4A?
I don't believe it does, Your Honor, and actually all of the evidence that came into trial, so even though the complaint said 4.4, all of the evidence that came into trial clearly acknowledged that he requested an accommodation and clearly acknowledged, and there was no objection to any of that, by the way.
Right.
And clearly acknowledged that thereafter there was adverse action taken, including, and we don't know what the jury found was adverse action, although we can interpret that based on the back pay, they thought
Damages.
that, yeah, that they thought that the failure to promote when Mr. Miller was first on the list would be adverse action.
Can you just address the opposing counsel's argument that it was an open captain, the position? Can you talk about?
Well, I think Justice Ditkoff said that. We asked the superintendent, was there an open position, and she said yes. I do have the appendix with me, but the transcript, but I'm not going to take up the time to go through it. But she also testified that it was her discretion. I think that buttresses the retaliation argument, because if it's her discretion and she exercised it not to make an appointment when Reggie Miller was first on the list, but then that list expired, he then became fifth, and she made 4 captain appointments. He was fifth.
So the captain vacancy is something different than the position of the assistant to the superintendent, correct?
I don't believe so. The person
not?
who was filling the assistant position was at the rank of captain at the time he retired.
Yeah, and
when
that
he
was filled with a
retired, there would
lieutenant.
because I think that they have a limited number of captain positions, but when one retires, you can then
Right,
appoint
what I'm
someone else.
asking is, at the time that he retired, could the superintendent, in her discretion, I think the answer is yes, but I'm just double checking, filled the assistant position with the lieutenant, and then also made a promotion to captain of someone else?
I don't know the answer to that, Your Honor.
So it's the same position that we're talking about, the assistant?
That evidence didn't actually come into trial because the vacancy that was at issue was the captain position that was filled by a lieutenant who, by the way, was later promoted to captain in that same position.
Say that again?
That person was later promoted to captain.
The person who filled the assistant
assistant
position, I see.
position in the same
But
position.
was lieutenant for some point while they were assistant, right?
I believe so, Your Honor, yes.
Which kind of establishes that that position doesn't have to itself be a captain, right?
It doesn't have to be, I guess. I mean, it
Well, I
was
mean,
all
it didn't.
discretionary, so it's hard to,
But the claim being that she did it this way as a pretext essentially to wait until the next list came out to promote people to captain.
That would be our argument. There was other clear examples of adverse employment action. After Reggie Miller filed his first MCAD charge, within a month, actually, the city filed for involuntary retirement for him. He'd been there, by the way, since 1996, just for the record. Then in November
Is that independently an adverse action, the letter?
Say that again?
Is that independently an adverse action?
Yes.
Why?
Because adverse actions, well, I'm going to skip to my favorite case in the Commonwealth, Bain versus the City of Springfield. It was my very first jury trial and my very first time in front of the SJC, and the defendant was the City of Springfield. So in Bain, it was sufficient for the Supreme Judicial Court that the mayor said, I want her gone. That was communicated to Ms. Bain. That was it. No discipline. She wasn't gone. And the SJC said that was enough. So yes, I would argue that an involuntary retirement at the time he was actually attempting to come back to work after exercising his rights both by asking for an accommodation and filing with the MCAD is an adverse action. But then there's another one. In November of 22, he files another charge alleging retaliation. And in March of 2023, he is disciplined for the first time since 1996. The lawyer for the city recommended up to a written warning. He was issued a written reprimand, and as was noted by Your Honors in my brother's argument, that was posted on the website. That could, and it said right in the reprimand, it could and did or might have affected his promotion. It's available to the public. It was up for 90 days, and that's the credentialing agency. So I think that is indisputably an adverse action. And again, under Bain, literally all that was said was, I want her gone, and she never went anywhere. Eventually she did, but it was voluntary. In the city of Newton, which is cited on page 13 of my brief, the Supreme Judicial Court found that the issuance of a letter of reprimand, this is page 13 of my brief, and the transfer to a rotating schedule were adverse actions. And that's what happened here, a letter of reprimand, at least the third thing. Punitive damages, I'll move on if there are no questions about the adverse action. And again, I'm going to refer to Bain, which was appealed by the city after a jury verdict in favor of Robin Bain. There were 0 compensatory damages. She was never terminated. She left voluntarily. There were 0 compensatory damages, and there was 0 in emotional distress, and $100,000 in punitive damages, and the SJC upheld that amount. In this case, if you combine the emotional distress and the back pay, it's about $188 and change, and $250 in punitives under Bain. That's clearly not outside the realm. And there's one actual additional factor that I just want to mention, and that is that if you're assessing punitive damages, and this is on page 16 of my brief, if you are a public agency, particularly one that is supposed to be enforcing the law, and these are the Clifton cases and the Cicerelli case, then you are actually held to a higher standard. A deliberate violation of 151B by those charged with the public duty to enforce the law, like a police department, presents a heightened degree of reprehensibility, and that comes right out of, it's either Clifton or Cicerelli, which is on page 16. So clearly there were adverse actions under Bain versus the city of Springfield. There were clearly adverse actions under almost any case law. And requesting an accommodation, even though you get it, that doesn't mean that after you get it, you can then be retaliated against. It would be like I request a leave to accommodate my disability, I come back and I'm terminated. That's clearly retaliatory. So the fact that they accommodated him, that's terrific. The fact that they retaliated against him violates 151B. If there are no further questions, I'll conclude.
Thank you. Thank you both. The case is
Thank you
submitted.
very much.
The next case is NIKLAUS v. Brink and another versus Barbara E. Hunt, case number 2025P838. You may begin.
May it please the court, I'm Barbara Hunt and am representing myself on this appeal. This is my first oral argument before the appeals court, and my only litigation experience has involved my condominium. My legal experience is in tax and real property law, but this litigation pertains to my long-term condominium that is my full-time home, and I'm trying to protect my only home. I will begin with context and then move to issues on appeal. This condominium property is in an 1860 building in a neighborhood filled with well-maintained 19th and 18th century homes. Few insurance companies will insure this property, and few lenders will lend and take a security interest in a condominium unit because this building is older than many underwriting standards. Varying from recorded condominium documents affects both unit owners and lenders who are named as additional insured parties and who hold security interests in the real property. Numerous technical rules applicable to a condominium are not merely words on paper. They enable unrelated condominium unit owners with little in common to conduct the business of the condominium through management by trustees, including maintenance and repair of the building and managing insurance policies and claims, so unit owners may have the peaceful use and enjoyment of their respective homes. Courts should not discriminate against small condominiums like this 2-unit condominium by refusing to apply and enforce the rules. Unit ownership in small and large condominium developments requires the same legal protections, and enforcement is essential. Court refusal to enforce condominium conveyancing and trust rules run through the history of this property. Any one of you would be standing in my shoes if you had purchased my condominium unit in good faith as I did. Nicholas Brink tries to present himself as someone with limited education, but he grew up in the world of family trusts. As the son of an attorney who served on the board of bar overseers, social law library, and at Hale and Dorr, where Brink's grandfather served before him. Brink has always had well-placed relatives who could make off-the-record comments to judges, enabling Brink to avoid the consequences of his actions as he lives his life in full rebellion against the values of his father and grandfather. It is difficult to win a case when Brink is on the other side. Nicholas Brink has profoundly different values and behaviors from his relatives whom you may encounter in your judicial roles. So if off-the-record comments regarding this case come to mind, please ask me questions directly so I can respond. Nicholas Brink has refused to transfer his individual title to his condominium unit into joint title with Lily Brink, despite her years of work on his landscaping and her work inside his condominium unit. So he remains the sole owner and trustee of his unit. He has refused to work with me as trustee, even though I'm a well-qualified attorney and experienced board member who has spent more than $200,000 of personal funds fixing up my condominium unit so I'd have a place to live for the rest of my life. I'm now retired. I live only on Social Security, having exhausted my savings due to medical reasons and the enormous number of hours I've had to spend on litigation regarding this property over many years, taking time away from earning a living. Brink's actions are systematic, willful, and deliberate and have profoundly damaged my property and my life, but he has never been held legally accountable. He's been given endless opportunities to correct his behavior and has refused. I began my career as the only female tax attorney in the room and worked to increase the number of women in my field. I did not expect to fight the same fight for my real property rights, but that has been my experience. I was able to graduate from Harvard with financial aid after attending public schools, worked my way through 2 law degrees, taught at the law school level, and practiced law for 12 years in Boston. I was trained in Massachusetts real property law by Peter Kilbourne, who went on to serve as Chief Justice of the Land Court and have served in complex, responsible roles throughout my career where fiduciary duty and confidentiality matter, including Harvard, Beth Israel Lahey Health Controller's Offices, KPMG, and EY. I have spent thousands of hours writing documents for courts regarding this condominium that would stack from the floor up to here, and I'm now asking this court to read and enforce the law. If you affirm the wrongful decisions of the trial court, I will not recover personally, professionally, or financially. You will destroy my home, my finances, and my professional reputation earned through almost 50 years of hard work. I've never breached my fiduciary duty. Given my current financial resources, it is impossible for me to pay an attorney to represent me, which is why I'm representing myself. It's impossible for me to pay Brink legal fees or to pay anyone to serve as trustee in my stead. If you affirm, I will have to go to the SJC, and if the SJC affirms, then to federal court. I'm being punished for following Massachusetts law, and that's wrong. I respectfully request that you write an opinion that will implement my property rights, including my right to determine the trustee for my condominium unit and provide a roadmap for a Superior Court judge who may lack training and experience in condominium cases. This case contains enough legal issues for you to write the lead case in the condominium area. There are many condominiums in Massachusetts, but few unit owners have legal training or the bandwidth to spend thousands of hours writing legal documents. Whether a condominium unit owner is a white woman, an African American, an Asian American, or person from another culture, each condominium unit owner has a right to have Massachusetts courts recognize and enforce their property rights. This is a case where a woman is standing up and demanding her property rights under Massachusetts law and will not take no for an answer. Please provide a solution in this case and a workable process for future condominium cases. I believe that if I had not installed fences with padlock gates and security cameras on my side of the property boundaries entirely within my exclusive use areas, the Brinks would have injured me to a degree that would have put me in a hospital emergency room. Their verbal and physical threats against me had continued for many years prior to my 2018 fence installation. The Brinks have lived in Florida and Maine since June 2023, but appear in person on Nicholas Brink's Dedham condominium property from time to time, most recently a few weeks ago in April. When they are absent, I'm able to live peacefully and enjoy my home and the neighborhood in which I live, but they remain a threat when they're on site. There's never been anything frivolous about this case or my prior legal positions in litigation. Certain judges erroneously believe that surveyors only mark property boundaries, but for condominiums, they're also required to label and provide boundaries for legally binding exclusive use areas on recorded condominium site plans, which is why that professional served as an expert witness regarding exclusive use areas for this condominium. A licensed land surveyor prepares, signs, reads, and implements legally binding property boundaries and exclusive use areas on recorded condominium site plans, all in accordance with detailed rules and procedures, including a title search supported by conveyancing standards. Actual use of real property does not change legal ownership as shown on a recorded site plan. The limited exception is an adverse possession
So
claim.
the site plan says what's exclusive. The backyards, the garage space, the front parking spots, the deck, but doesn't say anything about the front yard.
The site plan itself is what we are required to read. What happened in the case that began in 2012 and resulted in the final judgment was a decision was made that the recorded site plan would control and not the master deed, okay? So then you have to, and that is because when the Brink surveyor prepared the recorded site plan, the surveyor did not read the master deed. And so they're independent documents that conflict. So what we have to do is sit down and go through a legal reading of the site plan. And when someone who knows what they're doing, a licensed land surveyor or an attorney who can sign a title opinion, looks at that site plan, what they see is the following. They see a label that says exclusive use area. They follow the line down to the little diamond, which is the point of the arrow.
Right,
and
I'm
then they
looking
look
at
for the
it,
property
and it
boundary.
labels lots of exclusive things. Outside yard area in the back, garage space.
Oh, no, Your Honor.
Parking spots.
Excuse me.
Deck, and doesn't say anything about the front. There's no arrow to the front yard saying exclusive.
The only property boundary shown on the recorded site plan is the dashed line that you see that runs down the middle of the property, and it goes along the front, it goes up the side, and it goes across the back. There is no other property boundary shown. In order to, when you're looking at exclusive use area, you have to have the boundary completely surrounding the arrow that's at the point of that line. And that label applies to everything within the property boundary. The only property boundary shown on that plan is the one that goes all the way around half, that's my half, and half that's Nicholas Brink's half. There is no, in order to limit it in the way you have described, you'd have to look at that site plan and see a property boundary that went across the middle, sort of in front of the garage area, and that is not true. There is no property boundary on that plan that goes across the middle. The only property boundary shown goes all the way around the half, and therefore the only legal reading of that site plan is the one that includes the entire half.
Why aren't you bound by Judge Miller's decision?
No.
That's...
The Judge Miller
Why?
did not listen to a licensed land surveyor. The history of that is a bit of a mess, okay? That case started across the street in the morning in the district court because Lily Brink had filed a handwritten complaint, and I went over there and explained there was a case already in process with respect to these parties and this property across the street in the Superior Court, and so had it moved across the street. So then there was a hearing in the afternoon in the Superior Court on that, without attorney suite present. So Lily Brink did the speaking. Nicholas Brink was there, I was there. There were no witnesses. It wasn't a proper hearing or trial that had been planned in advance. It was an ad hoc get-together, and I think it's truly unfortunate that Judge Miller took that scrambled situation that was not a proper trial or proper hearing, and then proceeded to write something for which she had no legal authority. At the beginning, she looked at it and she said, well, I have no training. I don't know how to read a site plan. Let me just kind of do. And so she was kind of guessing. And then she really went out of bounds in sitting down and writing something that was totally unwarranted from the process.
Right,
We
but
had a
why,
proper
but
trial.
why isn't that binding?
Excuse me?
But why isn't that decision binding?
I think that what is legally binding is something that is supported by the law. And the law says that we have licensed land surveyors who do this work and create the plans and know how to read them. And if you have somebody come in who isn't properly trained and qualified, then that does not supersede the proper legal reading of the site plan. We had a proper trial with proper evidence that has led to this appeal. Judge Miller's writing should be understood in the very limited context in which it occurred, and she went far beyond where she should have, where she had Lily Brink standing up, pretending she was an attorney with no evidence in the record. I think we need to acknowledge the setting. Okay. Since I have no rebuttal today, I want to mention 3 topics on which the Brink attorney repeatedly tries to confuse judges. First, she regularly ignores the recorded condominium documents and presents legal analysis as though the condominium trust does not exist. So she throws all parties into the same pot without acknowledging the legal rights and responsibilities of a trustee, owner, and occupant, and repeatedly mentions the Brinks plural when Nicholas Brink has been the sole owner and trustee of his unit since the condominium was formed in 2003. Please acknowledge that the trust, as a legal entity that owns a condominium property, and the separate roles as you listen, because they're critical to the correct trust and condominium legal analysis. Second, in the appellee brief, the Brink attorney combined facts regarding 2 separate chimneys as though there was 1 chimney, thereby causing confusion. 1 chimney over the Brink unit collapsed in October 2020. Brink failed to rebuild it while retaining the trust insurance proceeds in his personal bank account where they've remained for more than 5 years. The 2nd chimney over the Hunt unit was taken down and rebuilt by a mason in September 2021. So the condominium trust could obtain a new insurance policy, and the trial court granted Hunt reimbursement for that work as part of the dollar amount owed by Nicholas Brink. Third, I've stated clearly I did not live in my unit from the fall of 2009 through June 2014, when KPMG required that I work in New York, yet appellee's brief continues erroneously to assert that I was present on this property doing yard work during that period. It remains my legal obligation to recognize the sole owner and trustee of for the Brink unit, Nicholas Brink, and to continue to try to work with him, despite his destructive and threatening long-term behavior, until such time as he sells his condominium unit or records a change of trustee for his unit at the registry. Extensive correspondence in the record shows that I've tried to carry out my trustee's duties in the face of Brink's refusal to act as trustee, and despite the ongoing threats to my safety and property that have rendered management of this condominium impossible. I'm keenly aware of trustees' fiduciary duties and have never in my life breached my fiduciary duties with respect to this condominium or any other fact pattern. Thank you very much.
Thank you very much.
Good afternoon, Your Honors. My name is Kimberly Sweet. I represent Nicholas and Lily Brink. As the panel is aware, this case has a long history. It goes back 16 years. I've been involved in those 16 years. This is the 2nd time these parties have been before the appeals court, and that is because both times Ms. Hunt has been dissatisfied with the trial court's decision. And that is why we are here, because she refuses to accept the judgment that the lower court entered. I would submit that the trial court decision, it was grounded on the evidence, it was reasonable, it was not clearly erroneous, and therefore it should be upheld on appeal. I mean, I do not believe that Ms. Hunt has met her standard of proof, her burden of proving that something was either clearly erroneous or there was abuse of discretion. The findings of fact were quite extensive. He gave multiple examples as to the relief that he gave, and I see no evidence in her brief that would overcome the decisions that Judge Tingle made at the trial court basis. Ms. Hunt, on one hand, in her brief, spends a lot of time talking about res judicata and how the 2012 judgment, which was the first trial these parties endured, has to be upheld and followed. In the very next breath, she asked the trial court to terminate the implied easements that were actually found in the 2012 judgment. She also asked this court to have a different interpretation of the Kelly plan, which the 2012 judgment said it's governed, it's clear, it's unambiguous. And so there's a lot of inconsistencies in Ms. Hunt's legal argument. I will just briefly touch on the main topics of her appellate brief. The implied easements that were found in the 2012 judgment, it was well thought out, rationale, explained, and Judge Tingle even put in his findings that her attempt to modify them now cannot be sustained. It's been settled. She appealed that decision, she lost. She asked the 2012 judgment to go up to the SJC. They declined to hear it. She cannot now stand before the court in 2026 and ask for that to be changed now. She also spends a great deal of her energy in her brief talking about the enforceability of the two stipulations that the parties signed in 2012 in November. Judge Tingle explained in the record that he found them to be governing rules that co-trustees are able to implement pursuant to Section 5.8 of the trust documents that actually just spell out how are they going to manage common areas of the property, how are they going to maintain them, and how are they going to administer the trust. It's uncontested that this document was signed by the parties. It's uncontested that they each had counsel when they reviewed and signed those documents, and then Ms. Hunt unilaterally repudiated those contracts. It's uncontested. And that, in fact, was one of the many reasons that the underlying judge determined that Ms. Hunt was removed as the co-trustee because she had violated her fiduciary duties. And just in summary, I know you've read the brief, but the judge found Ms. Hunt's conduct to be offensive, insulting, derogatory. Her behavior went beyond the pale. There was no evidence in the record that Mr. Brink or Ms. Brink did anything of the sort. Ms. Hunt, as one example, alleged that my clients were running, and I quote, a whorehouse out of their bedroom because their teenage daughter had an LED light in her bedroom. The level of animosity exhibited by Ms. Hunt toward my clients over years, it is a pattern of abuse. They just want this to end. They would prefer not to be here at all. And those are the facts that the lower court found. Touching briefly on the chimney issue, Your Honors. Ms. Hunt cites that there is a duty to repair and restore. She's referring to an antique chimney that for my clients actually had no longer functionality. They were transitioning from the oil to the gas right around the time that the chimney collapsed. This was an antiquated chimney. I do agree that there is a duty to repair in Chapter 183A. There's no dispute about that, but there is no obligation in the statute spelled out that we have to restore an antiquated part of a home that's not even functioning, and that was actually noted as well in the underlying judgment. Ms. Hunt was ordered to pay my clients entire legal fees involved in the underlying case, and I think that says a lot. There was a 4-day trial. There was extensive evidence.
What do you think happens if we affirm and she refuses or is unable to pay those attorney's fees or to pay an independent trustee?
So I'll take it in two parts. As a practical matter, if she does not pay the judgment, then I will ask for an execution on the contempt, and I will record it against the land. At some point, my clients need to be reimbursed for what they've been put through. Secondly, if she does not secure a successor proxy, which I have no doubt she will not, Your Honor, there is a contempt judgment that was issued in the fall of 2025 that said she had 30 days to suggest someone. She's never suggested anyone. And if not, the court would appoint someone. So that will be my plan, Your Honor, to address that. I understand that with a two-party condominium unit, the functionality is difficult. And that is what unfortunately happened in this litigation. And Ms. Hunt said something that I think is very telling in her presentation. She said she would not take no for an answer. That is exactly why we're here today, because she will not take no for an answer. If she doesn't hear what she wants, she will appeal again, most unfortunately. That's why these parties have not been able to have a functioning co-trustee relationship, because of the way she chose to operate herself and to conduct herself. I just want to finish with, because I think the issues are fairly, hopefully well spelled out in my brief. I want to address the request for legal fees that I included in my reply brief. I just want to do a very brief overview of what my clients have had to deal with in terms of the overly litigious behavior by Ms. Hunt. So we've discussed that they went to judgment in 2012. There was clarity. They were able to supposedly function from that. Just a few years later, in 2015, she filed a complaint against my clients, the exact same one that had just been relitigated. Yes, it was dismissed on the grounds of res judicata. My client still had to hire me. We had to engage in that action. In 2016, she filed a motion for relief from that judgment, the 2015 one. That was denied. She then filed a motion for a permanent injunction in 2017. That was denied. She then filed a motion for reconsideration of the denial of the permanent injunction. That was denied. She then filed another motion for relief from judgment. That was denied. She then filed, this is all in 2017, 2 subsequent interlocutory appeals, which were denied. When my clients filed the instant litigation that gives rise to the judgment we're all discussing here today, they were exhausted. They filed the current litigation to say, we just can't live with this. We need another co-trustee because nothing gets done. They were vindicated. She was removed. Ms. Hunt has not complied with 3 major components of that judgment, which was she hasn't secured a proxy. She was ordered to remove the fence that she erroneously placed in the common area in the front yard. She removed, there's 3 pieces. She removed 1. She refuses to remove the other 2, and of course, she's failed to pay the legal fees. My clients have asked me to express that they feel that unless there is an award of legal fees, I mean, they've already been awarded their trial fees. They've been, I believe, awarded fees on the contempt judgment, if I recall correctly. But for the this appellate case, Ms. Hunt will continue to continually litigate against them, and they just want this to end. So unless there's any further questions, I would just rely on my brief.
I don't see any. Thank you very much. Thank you both. The case is submitted. All right. Our last case today is Joanne Kelly versus John Kelly, case number 2025P225. This case is partially impounded. So, it's partially impounded, I believe, because of the financial information. So please just refrain from referring to anything that's impounded. Can you step to the podium, please?
Good morning. May it please the court. I'm Sandy Peserides for the plaintiff appellant, Joanne Lavita, formerly Joanne Kelly. We are here due to a judgment that was rendered in December of 2024. There was then an amended judgment in September of 2025, and then there was a supplemental judgment. All of these judgments reached the same conclusion, which, I'm sorry, the date of the amended judgment was February 5th, 2025, and the supplemental judgment was May 1st, 2025. They all incorrectly determine that the quadro at issue, which is a way that money is transferred in the probate and family court pursuant to a judgment that divides retirement accounts. So initially, the agreement for judgment entered on October 22nd, 2022. At that time, the balance in the appellee's Verizon 401k was about $358,901. What happened within days of Mr. Kelly signing that judgment is he withdrew $170,000. Oh, that was just in one transaction. The withdrawals totaled between October 13, 2022 and October 4th, 2024, $222,392, leaving a balance of $136,504 presumptively. Well,
no, hold on, wait.
Yes.
The documents say the balance at that point was $269,164.05.
In that...
On October 4th, 2024.
Correct, Your Honor. But by the time the withdrawals happened, I'm saying the immediate withdrawal of the 170 that happened on October 29th, 2022 left it so that there would not have been, just as a matter of math, the account balance then would not have allowed there to be the $179,000 that would have been required if we assume arguendo, and it's $179,450.99, that should have been the amount.
I don't get that. 170,000 times 2 is 340,000. So why wouldn't that leave enough to give half of the $358,000 balance?
Because he withdrew, that 170 was not all he withdrew. If you trace out the withdrawals that happened.
Right, but also it increases in value over time.
Yes, Your Honor.
How do we know on this record that at any point it was less than the half of $258,000 that your client owed?
Well, we do have the Verizon subpoenaed records that
Right, I'm looking at them, but
Right.
it tells me beginning balance on October 13th, 2022, and then it tells me the ending balance, and it tells me there's withdrawals and there's an increase, but it doesn't give me any amounts. I mean, I got all the withdrawals, but I don't know when the income came in. Can I tell that from this?
Your Honor, there are two distinct statements. So let me just. So that the record starts on the appendix page 179, which takes you through the various withdrawals and the net check amount. And then if you take that to the time of August 2023, when the quadro should have been, was presented and should have been implemented, that amount does not substantiate that figure. The ending balance was not enough when you subtract out the sums that were withdrawn.
But we can't just subtract, because during these 2 years, the account increases in value by $104,000. So how do we know when that $104,000 came in? How do we know what the balance is at any time between October 2022 and October 2024? And really, how do we know what the balance is on August 23rd, 2023?
Well, what we have, Your Honor, is them rejecting the quadro. Initially, they had approved it, and then we got a subsequent letter in January of 2024 saying that it was insufficient to, the account balance was insufficient to implement the quadro.
Right, with the additional gains and losses, but they didn't say it wasn't enough for half of $258,000 that I saw.
Your Honor, moving on from that inquiry, I do think it's here, but I'll have to relook at that piece. Moving on, even if we assume that arguendo, Your Honor, there still were clear and unequivocal actions taken to withdraw these funds in 18 distinct actions. And there's nothing that says that there was not to be gains and losses. In fact, all the evidence that we have subsequent to the parties signing that judgment that was incorporated on October 22nd, 2022, is we have them signing a quadro contract, which in and of itself is a legal document, saying that gains and losses will attach to the 50% of the amount that was in the account as of October 2022. Because if you take that to its logical conclusion, how else would someone be made whole for the fact that there is a lag time for the quadro to be processed in every scenario, for the judge to sign it and for it to be implemented by the plan? Always then someone should have the benefit of the money that goes with it, and that is specifically what Mr. Kelly signed on for. That was one act. Then subsequent to that, the parties signed a joint motion to implement the quadro with the gains and losses. And then the actual trial judge, Judge Milia, signed that quadro, making it an order in August 2023. That order was then initially sent to the plan. This happened with respect to the rejection by the plan due to the insufficient basis. We go before a new judge, new to the case, meaning not a new judge entirely.
But it sounds like on August 23rd, 2023, the amount plus the gains and losses couldn't be paid out at that point.
Yes, that's
already.
correct. That's in the record, yes.
So the order at the time it was issued was not something that could be complied with.
Right, and there lies the contempt, because if these withdrawals hadn't happened.
If an order can't be complied with at the time that it's issued, how can someone be in contempt of it when it's actually impossible to comply with it at the time they get the order?
Your Honor, it would have been possible, but for all these withdrawals. How do we treat the fact that $170,000, and this is just a matter of record, was withdrawn within 9 days of signing that agreement for judgment?
What did he do after August 23rd, 2023 that was contemptuous?
After that,
Yeah.
he refused to sign a quadro, then assigning the rest of the account balance to my client.
Where's the order? Where's the unambiguous court order that he signed that?
That's in the supplemental judgment, specifically saying that
I thought you were appealing the supplemental judgment.
Your Honor, I was, but it hasn't been stayed.
Are you saying he should have been found in contempt of the May 1st, 2025 judgment?
Your Honor, or the one prior to that. The order was never, the judgment's not stayed to this day. There were two judgments subsequently.
All right. When did you ask for him to be held in contempt of the May 1st, 2025 judgment?
I have not filed a subsequent contempt.
All right, so I guess, let me try this way. I understand that you would like us to reverse the decisions in December of 2024 and February 2025, finding him not guilty of contempt. Is there anything else you want us to reverse?
Yes, Your Honor. I want to reverse the order of fees because it does not require a willfulness.
No, I understand. If he's found in contempt, you get fees.
Yes.
So that's part of appealing the not guilty on contempt. I get that.
Sure.
If he's found if we reverse the not guilty of contempt, then you're going to get fees and you're going to get a remedy for the contempt. But is there anything else?
Yes, Your Honor.
Okay,
the court judgment specifically required him to work to implement a new quadro. He's done nothing, and the record that we do have shows that he's not.
Now, this is again the May 1st court order.
Right, Your Honor, but that order is still in place. That judgment continues to be in place.
I understand, but we don't get to order things directly. You've got to appeal decisions of the probate judge.
And I have.
And I get that you're appealing the not guilty. Is there anything else the probate judge did that you want us to reverse?
Yes, Your Honor. I want she vacated the initial quadro sua sponte. That was no part of the relief. That was its own independent order of another judge, and she sua sponte vacated it. She also failed to set in any other mechanism other than saying he should work cooperatively to sign the quadro. He hasn't affirmatively done anything. You have to pay these quadro preparers. They have to make a document. He's rested on his laurels, and now my client is 3 years post-judgment and has no funds awarded to her on a 20-plus year marriage. That cannot be fair. These folks were married for 20-plus years. They're the parents of 7 children. My client's not a person of means. Meanwhile, her accounts were notably divided with him with carry-forward gains and losses.
So what thing on the May 1st, 2025 judgment are you appealing?
Your Honor, the May judgment is largely just, the May judgment, she makes no findings. She doesn't specifically order anything to happen. She says that my client wishes to appeal and the other party feels he's complied. She mentioned, that judge specifically mentions that the parties should try to see if they can fashion a solution to the controversy, but it does not affirmatively put any obligations on any of the parties. So I guess a lot to say that my true gripe is with the supplemental judgment that was issued May 5th, 2025, because the next judgment.
Wait, May 5th?
Yes.
Is there a notice of appeal of that?
Yes, Your Honor. So there's May 5th, and there's the judgment of, and I'm looking at it now, 2/7/2025 is the one that says that the quadro incorrectly provides the adjustment for earnings, gains, and losses, ignores the question of what should happen with my client's share, the gains and losses, and how she'd be made whole for the passage of time without any funds whatsoever, and then vacates that quadro of August 23rd, 2023, and it says the parties should work together to forthwith file an amended quadro for approval to reflect a lump sum of $179,450, and again, doesn't then fashion what happens from this new quadro amount to now. Why should all the gains that are happening in the course of the fact that the judge who didn't hear the case at any time while it was, at a trial mode, but only post-judgment for contempt, makes a change to an order signed by that judge that defeats my client of all growth? And as you said, there's been, to your point, there's been additions, there's been growth. That's uncontroverted in the Verizon records. Why would the person who made the withdrawals that caused my client to not get the benefit of her bargain get all the gains and losses and any incremental change? There's no question that money has and continues to appreciate. So any other result would give one party all that benefit.
In your brief, under the statement of issues, your 5th issue is whether the court abuses discretion by vacating the QDRO.
Yes.
But then I didn't see anything in your argument section about that. Did I miss it? Your argument section sort of ends after the 3rd.
Yeah. So, Your Honor, with respect to the vacation of that order, the judge has now decided, the judge who issued that contempt judgment, what portion of the previous judgment. I
get that. I'm trying to find out where in your brief you briefed that. Because I see 4, you say an amended qualified domestic relations order should issue, which of course is exactly what the judge ordered. So where did you say that it was an error to vacate? Where did you brief that it was an error to vacate? I see it in the statement of issues, but it's not in the argument brief as far as I can tell. And of course, we can't reverse on anything that isn't briefed.
Well, Your Honor, where I argue on page 27 of my brief that the trial court erred in failing to consider extrinsic evidence of the party's interpretation of the agreement for the judgment, the purpose of that argument is to show that the court should be in interpreting the quadros, and I specifically say that both the appellant and the appellee signed the qualified domestic relations orders, which included market gains and losses, as well as signing and implementing 3 additional quadros. So in that sense, then, what has happened by vacating that order is that my client doesn't have the benefit of the bargain. So now one party who's partially performed, which is my client, through good faith, signed the quadros that divided her deferred comp account with the MBTA with gains and losses, and now the quadro that would have divided husband's account with gains and losses is vacated. So now a miscarriage of justice has happened because one party gets one implementation of the underlying judgment and the other party gets a far less beneficial implementation
Right, but didn't
of
the
that.
judge order that that was going to be fixed in the May 1st, 2025, that he'd have to pay the extra amount?
No, there's no order that says that.
Well, it says, Mr. Kelly acknowledges he may have received gains and losses on accounts inappropriately based on the judgment of divorce.
Right.
And then it says that this will be reviewed further.
Right, and never was. And at the next hearing, when it was to be reviewed...
That's actually, why is this case just stopped?
Well, at the next hearing, when it was to be reviewed, the Judge Anthony, who heard the initial contempt, said that there were not going to be any further orders in this, and it's on appeal, and the appeals court would make a decision. So nothing further was done, and the matter is concluded at the trial court, pending if anything changes here. So that visiting judge, who was Judge Baracco, that signed the May 5th, 2025 order, she may have made some dicta in her decision, but there is no actual affirmative obligation placed on him, and that's why I said my underlying gripe isn't with that May 5th, 2025 order, because there's no finding of guilty or not guilty. It's just called supplemental judgment, and it just gives a summation, apparently, of the judge's findings based on the status, but nothing affirmatively is to happen. So the only affirmative changes happened with respect to the previous amended judgment of February 7th, 2025, which is where the judge takes away my client's entitlement to receive gains and losses and specific...
Okay, you're well over your time, so we're going to have to leave it there.
Thank you.
Okay, thank you. Okay. Mr. Kelly.
Thank you, Your Honors. I'm Mr. John Kelly. I don't want to waste the court's time. My brief stands for itself, and I try to stick right to the issue. The agreement was the agreement. Interest in gains was not part of the agreement. That was clear. Both parties knew it. This all goes on. They've made no effort to negotiate, to work something out. They made it clear in court that they had no interest in negotiating. There's not much I can do. She's missing out on this money. That's between her and her attorney. This should have all been settled long ago. Those quadros, they weren't meant to, they were meant to implement the agreement, not to modify it. And that's exactly why they were vacated. It was vacated by the court. So That's really all I have to say on it. I'll take any questions and try to answer any questions best I can.
I don't see any questions, so thank you very much.
All right, thank you.
We'll take it under advisement. The case is submitted. That concludes our sitting for today. Thank you to the court officers and the clerk's office and our timekeeper. We are adjourned.